Sometimes I don't speak as loud as I should, but I'm going to try today. Again, just raise your hand if you can't hear me. I'll make sure I restate. All right, so today's case is Washington State University, an institution of higher education and agency of the state of Washington. Kirk H. Scholes, in his official capacities as the president of Washington State University and chair of the Pac-12 Board of Directors. Oregon State University, an institution of higher education and agency of the state of Oregon, and J.I. Murphy, in her official capacities as the president of Oregon State University and member of the Pac-12 Board of Directors. Plaintiffs.
Recording in progress.
That's good. Recording in progress. Versus the Pac-12 Conference and George Kalitakov, in his official capacity as commissioner of the Pac-12 Conference, Defendants, and University of Washington, an institution of higher education and agency of the state of Washington, intervener, defendant. All right, so that is the official caption, case number 23-2-00273-38. Try to organize myself here. Okay, so let's go, and if I would have, we could go ahead and have the plaintiffs introduced. I think it's Eric McMichael will be representing the plaintiffs today.
Yes, Your Honor. Good afternoon. Eric McMichael, seated at counsel table is my partner, Nick Goldberg, my client, Ms. Ghost, the general counsel of Oregon State University, and in the stands we have Scott Barnes, the athletic director of Oregon State University, and I'll let my colleague, on behalf of Washington State, introduce their attendees.
All right, thank you, Mr. McMichael.
Good afternoon, Your Honor. Ariana Scavetti of Weil Gotshal on behalf of Washington State University. I'm joined by my colleague, Katie Clemens, as well as Nathan Dean from the Office of the Attorney General. We also have with us today President Kirk Schultz, the president of Washington State University, and athletic director Pat Shahn. And President Schultz had to fight through some fog and flight cancellations to be here, so we're glad to have him with us today.
And could I just have you spell your last name?
Absolutely. Scavetti. S-C-A, V as in Victor, E-T-T-I.
All right. Thank you, Ms. Scavetti. All right. That takes care of the plaintiffs. So let's go now to the Pac-12 Conference. And that would be Mr. John Cadigan or Mr. Gregory Merchant?
Mr. Mark Lambert.
Mark Lambert.
Yes.
Okay, Mr. Ball. All right.
Good morning, Your Honor. I'm Mark Lambert on behalf of the conference defendants. With me at counsel table are the general counsel of the Pac-12, Scott Petersmeyer, and our local counsel, John Cadigan.
Good afternoon, counsel. All right. And let's go then to the University of Washington. And I believe that is James Buter. But I might be incorrect.
100% correct, Your Honor. Thank you. I'm used to mispronunciations, and that was not one. James Buter, Assistant Attorney General for the University of Washington. And here with me with pending Pro Hoc Vice applications, Your Honor, are Dan Levy, Brian Heckenlively, and Hyland Chen.
Okay, and I think I've signed orders for them to appear pro.
Have you, Your Honor? Okay.
Well, I think I signed a bunch. I don't know. I will if you want me to.
Yes, please.
All right.
Thank you, sir.
You can hand those up to the clerk and we'll get those signed. All right, and then we have the amicus curiae 9 absent schools, and I think they're represented here by I think Mark Ellinson, Janet McPhee, or Stephen Dixon, but I may be wrong.
Your Honor, Daniel Levin from Munger, Tolson, Olson, and we are representing the 9 amici.
Yeah, because
Just remember to use the mic, please.
then the overhead.
Good afternoon, Your Honor. Daniel Levin from Munger, Tolson, Olson, and we are also representing the amici schools.
And it's Daniel Levin, L-E-V-E-N?
L-E-V-I-N.
Thank you.
Thank you.
Clerk's new to all these names, and she's got to take them down and put them in the minutes, so try to get the spellings correct. Okay, so no Mr. James McPhee or Mr. Mark Ellinson. Okay. All right, well, as you all know, this matter is before the court today on a motion for a preliminary injunction by the plaintiffs and a motion to dismiss by the Pac-12, the University of Washington, and the amicus curiae 9 absent schools. The think there are more attorneys in this case than the total combined in Whitman County, Adams County, Silver County, Columbia County, Garfield, and Lincoln counties together. Observation. Because I go to all those counties and they don't have as many as what you have here, what we have here. A few preliminary comments. Just to let you know, Colfax is known to have one of the greatest ghost institutions in the world. Yes, the old St. Ignatius building just down Main Street is known to have many ghosts who continuously haunt the building and who bring hundreds and thousands of ghost hunters right here to Colfax every year. Why do I mention this, you ask? Well, because a few hours ago, when my court administrator and I were pulling in chairs from the jury room, there was a ladder up through the hole, and I could hear, I thought I heard a voice coming down for me while I was in the jury room. And it sounded like a faint voice. It sounded like somebody familiar. I listened carefully, and as certain as the voice was, it was that of Bill Walton, who was proclaiming the Pac-12 the Conference of Champions. Kind of pretty eerie when you think about it. Thought that was, I've heard that so many times. We've done. Okay, we would like to introduce our courtroom security. Whitman County Deputy Sheriff is here, and he'll. We didn't get Corey Alcantar, apparently.
You have to wait till Thursday.
Okay, all right. Corey Alcantar, he's the biggest, toughest deputy sheriff we have, and but we've got the second here, so we've got security. All right. Okay, and okay. The court administrator set this case for 1 hour today, but there's nothing else scheduled in court today, so I suspect we will take as much time as you need. So we've got it. There was no mention of any testimony for today, so my understanding is the court will decide the issues today based upon the declarations, memorandum, and I also understand that for purposes of today, there are no material issues of fact. You can correct me if I'm wrong when you respond. The court has read all your materials, actually 2 and 3 times, and thank you for all providing organized bench copies. They're all up here in order. And the court has read hundreds of pages of legal memos, declarations, and attached exhibits, well over 500 pages. The Pac-12 bylaws alone are about 250 pages, which have been provided twice in the materials. And by the way, there is, and one of the things I noted when I read that, the bylaws, there's no dispute resolution clause and no jurisdiction or venue clause in the event of a dispute. In my 41 years of private practice, I cannot recall drafting a contract without a dispute resolution clause, including a jurisdiction venue clause. Note to other conferences, you better look over your bylaws because the absence of a dispute resolution clause may come back to haunt you. All right. And also, missing from the bylaws is a liquidated damages clause or a penalty for leaving early clause, which I read about other conferences like University of Maryland had to pay $30 million to leave the ACC. I do not see that in the bylaws, but if I miss that, I'm sure I will be corrected. This court has also received 2 three-ring binders of cases printed in full from the University of Washington, some 50 cases here in these notebooks, without any synopsis or explanation which each case was relevant to. The court has also received another 3-ring binder of cases printed in full with concurring and dissenting opinions, some 15 more cases without any synopsis or explanation which each case was relevant to. So the court is not sure what you wanted the court to do with some 75 cases. Again, there was no synopsis, brief, or short summary of each case. Reading all these cases without a synopsis is not a realistic request to this court and nor a meaningful way to support your client's position. I have them, but without some reason to read them, I did not. The filing of the 75 case is without synopsis, brief, or explanation of what you want the court to specifically read, as I would believe is not a good way to enhance or support your arguments. Nevertheless, they are here, and if you want to point to them in your argument, you may do so. Okay. A few notes. Now, my big note here is that I was optimistic that you all would not be back here today, that the very experienced retired federal court judge could successfully mediate your disputes. That's too bad, because now the resolution of this most challenging case is no longer in your hands. Now the resolution is in the hands of the court, where decisions usually displease all concerned. And we're going to just have this question answered later. Does any party here think that if you all had more time for meeting, that a resolution of this case could be resolved? I'd like you to answer that when we get started. This court has the discretion to allow amicus curiae participation, that is, friends of the court, who in this case are the 9 remaining universities of the Pac-12. If such participation would be helpful to the court so finds, and the court is glad to recognize amicus curiae and for amicus curiae to participate in this case. Note to public, amicus curiae are not officially parties in this case, but certainly want their voices heard in this lawsuit, since the outcome will and may probably affect them. Okay, we'll start out by each of the 3 parties, the plaintiffs, Oregon State University, Washington University, then the defendant, Pac-12, then the defendant, University of Washington, and then the amicus curiae stating what they want and why in about 10 minutes. We'll then go back around in the same order with replies of 5 minutes from each party and from the amicus curiae. The court will have some questions as you proceed. Also have a list of questions if they are not addressed in argument. We all know that this case will be ultimately decided by the 9 justices in Olympia or Washington, D.C., so whatever decision this court makes today will only last as long as it takes for this case to get there for review. Unless we can work out a settlement or an agreeable resolution with all concerned today, which would be something that we could, that I hope can be achieved. The court has outlined each of the parties' motions, briefs, and declarations. I will probably refer to my notes from time to time as I have questions noted and comments noted. We just review the outline of the documents that I have reviewed. I've reviewed them all, as I say, 2 or 3 times. The October 9th Pac-12's motion to dismiss. The October 9th amicus curiae in support of the University of Washington motion to dismiss. The October 12th University of Washington's response to motion to intervene. There wasn't any objection to that, of course. October 12th, the University of Washington motion to dismiss. October 20th, the plaintiff's consolidated opposition to the defendant's motion to dismiss. And October 25th, and I'm using the date stamps here, the plaintiff's motion for a preliminary injunction. October 25th, the proposed order granting preliminary injunction. October 27th, the University of Washington reply in support of its motion to dismiss. The November 2nd, Pac-12 opposition to plaintiff's motion for preliminary injunction. On November 2nd, the University of Washington's opposition to plaintiff's motion for preliminary injunction. October 9th, the plaintiff's consolidated reply in support of the motion for preliminary injunction. And that is, there is another reply on November 9th. Yeah, that's all part of the plaintiff's consolidated reply. So I've reviewed and outlined on old yellow legal paper once if you each want to make. I want to say one thing here before we get in the argument. When the court makes its decision, please do not make any reactions here in court. No shouting, ringing, high-fiving, or any tomatoes. This isn't a football game, and thank you for your cooperation. All right, so we'll start with the plaintiff's motion for a preliminary injunction and the reasons why.
Thank you, Your Honor. Eric McMichael on behalf of Oregon State. And with the court's permission, we've prepared a PowerPoint presentation that I can hand up to the court.
You may, sure.
Thank you, Your Honor. And just so I understand, Your Honor, you'd like me to keep my comments to roughly 10 minutes at this point?
Well, how long do you think you need?
Well, to be honest, to get through the entire presentation, I had budgeted a lot more time, but I'm happy to try to hit the high notes for the court now and then follow up on any aspects that you would like me to elaborate on further.
Well,
So
I want everybody to be able to have time to say what they want to say.
Okay.
But we've got 2:15, we've got some time limitation. So let's start out with
Okay.
how about we start out with a 20-minute first round.
Okay, I'm happy to do that, Your Honor, and I'll try to police myself on the time, but thank you. Thank you, Your Honor, for hearing this very important matter. It's nice to be back in Colfax. We, the plaintiffs, are here today seeking a preliminary injunction which preserves the plaintiffs' governance rights under the bylaws of the Pac-12 as the sole remaining members of the conference, and also preserves the interpretation of the bylaws that the defendants and the vast majority of the departing schools adopted and ratified time and time again for more than a year leading up to this dispute. And Your Honor, I've organized my comments today around 4 key points, which you can see on slide 2 of the presentation. And the first key point is that Washington State and Oregon State are likely to prevail on their claim here that under the bylaws of the Pac-12, members who deliver notice that they are leaving the conference to join competitors are no longer entitled to sit on the board or vote on behalf of the Pac-12. It is the exact same issue that we took up back in September, and the evidence produced in discovery since the temporary restraining order only confirms that the court's preliminary ruling was correct. We have a mountain of evidence that's been produced in discovery, and it overwhelmingly supports the plaintiff's interpretation that under the Pac-12 bylaws, if you deliver notice that you are going to leave the conference, that at that moment you are automatically off the board and you are no longer entitled to vote on any matter pending before the board because you have a conflict of interest and you are no longer able to represent the Pac-12 conference loyally as board members are required to. The second key point is that the parties' prior course of conduct uniformly supports the plaintiffs in this case. The evidence shows that for 13 months leading up to this dispute, the conference applied the bylaws in a consistent manner that supports our interpretation and rejects the departing school's interpretation. For 13 months, the board of the Pac-12 ratified that interpretation time and time again by meeting and making significant decisions as a board of 10, not as a board of 12. And for 13 months, neither the conference nor the 10 remaining board members ever said that they disagreed with our interpretation of the bylaws, not once. So this interpretation that the University of Washington is coming into court with is just a direct reversal of the position that it, the conference, and the vast majority of the departing schools took for 13 months. And there isn't a single document that's been produced which shows that the University of Washington thought that this was the correct position until it provided its notice of withdrawal, and now the shoe was on the other foot. But parties are not allowed to just blatantly flip-flop on the meaning of contractual provisions just so they can have their cake and eat it too, Your Honor. The third key point here is that Oregon State and Washington State will suffer irreparable harm without a preliminary injunction. It is no understatement to say that this is a crucial time for the Pac-12 Conference, and the board needs to be able to act now. And plaintiffs are the only eligible members to sit on the board because we are the only members who are not hopelessly conflicted. And if Oregon State and Washington State are not entitled to act as the board now, as the bylaws dictate and require, then there very likely will not be a conference left to save by the time that our rights are fully adjudicated through the final resolution of this case. So now is the time that the plaintiffs need to be able to act as the board, as the bylaws require, and based entirely on the actions of the departing schools who have announced that they're leaving to join competitors. And finally, Your Honor, I want to address a couple of the red herrings in the departing schools briefs to explain to the court why several of the arguments they're making we think are really just an effort to distract from the central question before the court, which is whose interpretation of the bylaws is more likely to prevail in this case. That is the key question for the court. So let me dive right into that, Your Honor, and I'm going to jump to slide 4 of my presentation. The fundamental question here is whether, under the bylaws, schools who have provided notice that they are leaving the Pac-12 and joining competitor conferences are still entitled to vote on behalf of the board during their remaining time in the conference. Or, alternatively, is it the case that if you provide notice that you're going to leave, you are automatically removed from the board and no longer entitled to vote on behalf of the Pac-12? And plaintiffs respectfully submit that the bylaws provide a direct answer to that exact question. So if you turn to slide 5, Your Honor, which contains Chapter 2, Section 3 of the Pac-12 bylaws, and I know the court is well familiar with this language at this point in time, so I won't belabor it, but there's a couple points I want to make here. As it pertains to the dispute that is before the court today, there are 2 critical provisions in Chapter 2, Section 3. The one first is the very first clause of this, which says that no member shall deliver a notice of withdrawal to the conference in the period beginning July 24, 2011 and ending August 1, 2024. And Your Honor, a notice of withdrawal is exactly what it sounds like, a notice that you are going to withdraw. And this is saying in plain language, during the current media rights deal, don't give notice that you are going to leave and join a competitor because that will hurt the conference. The Pac-12, like any organization, has a commercial interest in making sure that its members stay and also in making sure that its members stay loyal while they're in the conference. And there's no dispute that the notices of withdrawal provided by USC and UCLA cause significant harm and significant injury to the Pac-12. So this clause is trying to provide a disincentive to members leaving the conference. And it's saying during the current media rights deal, don't give notice that you plan to leave and join a competitor. And the second critical provision, Your Honor, is in the last sentence, which we've also highlighted, and that says very clearly, additionally, if you do deliver a notice of withdrawal prior to August 1, 2024, then you are automatically off the board and no longer entitled to vote. And that rule makes perfect sense because members who have announced that they're leaving at that point have a conflict of interest. They no longer have a duty of loyalty to the Pac-12, and they can no longer act on behalf of the conference. So, Your Honor, this middle section in Chapter 2, Section 3, the unhighlighted language, this is where the departing schools focus all of their analysis and all of their attention. They barely mention the first clause or the last sentence. Instead, they focus all of their analysis on that middle part. But that middle part is addressing a separate concern that is not present in this case. And it's important to remember, Your Honor, that the drafters of the bylaws had to consider 2 possible scenarios. If a member said that they were going to withdraw, that could either be they're going to withdraw before the expiration of the current media rights deal on August 1, 2024, or they could provide notice that they're going to withdraw after. So if they're going to withdraw before, that would put the conference in breach of its media rights deal, and the conference would need to have the ability to seek injunctive relief to prevent that. But if the notice provided said that they were going to withdraw after August 1, 2024, which is what happened here, then the injunctive relief in this middle clause is not necessary and not relevant. But the remedy provided in the last sentence becomes paramount and kicks in. And that's why the remedy in the last sentence begins with the word additionally. It's providing a separate and distinct remedy from what's contained in the prior sentence. And that remedy is to remove board members once they announce their intent to leave, because it's at that point that they no longer have loyalty to the conference. And so our interpretation, the interpretation that the court preliminarily adopted at the TRO, is the only way to read this section as a whole, giving meaning to each part, which is what the court, of course, is supposed to do. And if you look at slide 6, you can see the court's temporary restraining order ruling, which found that the plaintiffs are likely to prevail on their claim and adopted the interpretation preliminarily that we just walked through. So, Your Honor, let me spend just a minute or two talking about the departing school's interpretation of this section. The departing schools, led by the University of Washington, are now, and I really cannot emphasize strongly enough the word now, are now coming into court and saying that our interpretation is absurd, it makes no sense. They say that it's atextual, which is a word that I honestly had to look up.
What does it mean?
I'm still not sure I know. So, and they proffer a different interpretation of this provision. And while they spend many pages explaining what that is, I think it can be distilled down to what's on slide 7 of our presentation. And what the departing schools are essentially arguing, as I understand it, Your Honor, is that when the bylaws say no member shall deliver a notice of withdrawal during this period, what the bylaws really mean is no members shall withdraw from the conference during that period. The departing school's entire argument hinges on delivery of notice of withdrawal to mean actual withdrawal. And the departing schools are saying that this entire chapter only applies in a situation in which the member actually withdraws prior to August 1, 2024. They're saying that this chapter does not address in any way the current situation in which a member announces that they're planning to leave after August 1, 2024 to join a competitor. And according to them, there's no consequence at all to a member who announces that they are planning to leave to join a rival conference. According to them, they're still entitled to be on the board, they're still entitled to vote, and they're still entitled to vote on crucial issues like how to allocate the remaining revenue over the next year, whether or not to make any provision for the liabilities that the conference has incurred during the time that they were in the conference, but which liabilities will not come due until after they leave. They get to decide, according to them, how the conference should invest that money to regrow for the future, or whether it should invest any money to regrow for the future. So that's their interpretation of this. But there are just several fundamental problems with that interpretation, and I'll go through them very quickly just in the interest of time. But if the court has any questions about what any of these arguments or problems are, I'm happy to stop and explain. The first problem is it's just not what the bylaws say, Your Honor. The bylaws say don't deliver a notice of withdrawal during this period. It doesn't say withdraw. It easily could have been written differently, but they triggered the remedy to the delivery of the notice because that's when the injury occurs to the conference. The other key point here, Your Honor, is that under the prior version of the bylaws, it's undisputed between all the parties in front of you today that the term notice of withdrawal meant deliver a notice before you actually withdraw. That's what it meant in the prior version of the bylaws. And by using that same term and carrying that term forward into the current version of the bylaws, I think the court should assume that the drafters intended for that same meaning to come along with it. It would be very unusual to take a term with a specific understood meaning and apply it again, but intend to change the meaning without signaling that in any way. Now, on that same point, it was also the case in the prior version that if a member did provide notice, they were automatically off the board. And again, there's not a single piece of evidence to suggest that anyone intended to change that result between the prior version and the current version. So I think when you look at the history of the bylaws, again, it confirms and supports our interpretation. It also renders, I'm on slide 9 now, their interpretation renders the last sentence of this provision entirely meaningless. Why would you need to specify that people who have actually withdrawn are no longer on the board and can no longer vote because they would not actually be in the conference at that point? So there would be no need to actually say that you're off the board. So their provision basically reads that last sentence of this chapter entirely out of the bylaws. And that's a real problem, and I'm on slide 11 now, because that sentence actually begins with the word additionally. And it's a well understood canon of contract interpretation that whenever you begin a sentence with the word additionally, what follows is intended to be a separate and distinct provision in the section. So that's why they say additionally, setting aside everything else, if you provide a notice of withdrawal, you're off the board. And that's intended to address this conflict of interest problem that existed in the prior version and also in the current version. So just going through, Your Honor, I want to jump to slide 15, or actually let me jump to slide 17 if the court will allow me to jump ahead. And this is really a critical issue in this case, which is, and I have a timeline here on slide 17, and what the evidence that's been produced since the TRO shows uniformly is that between June 30th of 2022, when USC and UCLA announced their departures, and August 2023 of this year, the conference and the remaining 10 board members took the position that schools who announced that they were leaving after the expiration of the current media deal were automatically removed from the board. That was the course of conduct during this entire time from June 30th, 2022, all the way up through August of this year. The evidence also shows that the 10 remaining schools, including the University of Washington and its president, who was the chair of the board during most of this time, knew that USC and UCLA had been removed from the board. They knew why USC and UCLA had been removed from the board, and they repeatedly ratified that decision, and they repeatedly ratified the interpretation of the contract, of the bylaws that we are advancing. So the evidence on course of performance in this case overwhelmingly supports the plaintiff's position and confirms that we have demonstrated a likelihood of success on the merits of our claim. And Your Honor, it's not like there was nothing happening at the Pac-12 during this entire period of time that's laid out in our timeline. If you look at the next page, what you can see is there were more than 20 board meetings of the Pac-12 during this time period, during which USC and UCLA were not entitled to attend a single one and not entitled to vote on a single issue. During this entire time, this was a board of 10 because 2 of those schools, USC and UCLA, had said, we're going to leave in August of 2024, and everybody agreed that means you're off the board and you can't vote, which is what we're saying in this case. And these are all very smart people, these chancellors and presidents of these universities. They know how to count. They know the difference between 12 members of the board versus 10 members of the board, and they were told exactly why USC and UCLA were off, because they had provided notices of withdrawal, and they knew exactly what interpretation of the bylaws the conference was taking, and they never disagreed with it. Instead, they ratified it again and again and again. So for them to come in here and say that our interpretation is absurd or it makes no sense, it's atextual, is very ironic, given that the University of Washington, the conference, and 8 of the 10 departing schools all agreed that that was the right interpretation for more than 13 months, and they only suddenly decided that it was the wrong interpretation after they all announced that they were leaving to join competitor conferences, and now the remedies that they had imposed on others were going to be imposed on them, and that's how we arrived at this new found interpretation.
Was there any action the board took against USC or UCLA for withdrawing from the conference? Did they just lose their board seat, or was there anything done with respect to their interests?
Sure, very good question, Your Honor. So they at least twice in the record that we've seen, the board, which means the conference and the remaining members, considered imposing penalties on USC and UCLA. They considered reducing their distributions, and this is literally laid out in presentations. They considered doing that. They never actually did. But during the time that USC and UCLA were off the board did make decisions like reducing distributions for everyone. They made critical decisions like how to allocate cash reserves to budget shortfalls. They made decisions about settling litigation. So the board of 10 was making very significant decisions that had real-world impacts on USC and UCLA, including reducing the money that they were getting and have received. And nonetheless, they still were not entitled to attend, vote, or even know what was happening because they were automatically removed as the bylaws require. So the suggestion in the departing schools briefing that the 10 board members didn't know what had happened with respect to USC and UCLA, that it was somehow opaque to them, has just completely been disproven by the record. In the presentation, I don't have time to go through all the slides. I'm happy to show you if you want, but they were specifically told on multiple occasions about the fact that these schools had provided a notice of withdrawal. They were therefore off the board, and they knew that they were still in the conference, but they were planning to withdraw in the future, and that meant they were off the board. So everybody knew that that was the right interpretation until that interpretation no longer suited them, and then suddenly it was the wrong interpretation. So, Your Honor, I want to jump ahead just in my remaining few minutes to slide 39, if I may. And I want to hit the third key point in this case, which is that Washington State and Oregon State will suffer irreparable harm without the preliminary injunction that we've requested.
What page are you on?
I'm sorry, I'm on slide 39 of my presentation. And I'm sorry if I'm moving fast. I'm just trying to lay out as much as I can here.
Sure.
So unless a preliminary injunction is granted, the plaintiffs will lose their governance rights guaranteed to them under the bylaws to act as the board of the Pac-12, and they will lose the chance to try to chart a path forward for this conference. And we cited numerous cases in our briefing, Your Honor, saying that the loss of governance rights constitutes irreparable harm and gives rise to a preliminary injunction, and the defendants had no response whatsoever to those cases because there is not one, frankly. And courts have, as we laid out, consistently recognized the unique and intrinsic value that governance rights confer, and they also recognize that if you are deprived of your governance rights within an organization, that harm is irretrievable and cannot be measured by monetary damages. It cannot be redressed later if you're deprived of your right to govern in an organization if you have that right. And I don't know how there could be a more clear demonstration of that rule, that the loss of governance rights constitutes irreparable harm, than the situation you have here when you consider two things. One is, as I said earlier, now is the crucial time for the Pac-12 to try to plot a course forward. The board needs to be able to act now, and the board needs to be able to act in the best interest of the conference, not in the best interest of individual members whose agendas no longer align with the Pac-12 conference. The second key point is that without the preliminary injunction, essentially what we are doing is saying that the conference's future is going to be decided by 10 members who are hopelessly conflicted and no longer have any loyalty to the Pac-12 because they've pledged their futures to competitors. They have no incentive to invest $1 in the Pac-12 because they're all leaving to join the Big Ten, the Big 12, or the ACC. And the opposition brief that we received from the University of Washington, I think, confirms very frankly what the departing schools' plans are if they are granted any authority to govern this association. They want to distribute all the revenue to the members, including mostly to themselves. They don't want to invest $1 in going out and regrowing the Pac-12. They don't want to invest $1 in recruiting new members because there's no upside for them in the Pac-12 growing or going on. They're going to conferences to compete against the Pac-12. So they have no incentive to do anything other than distribute the money to themselves, leave their liabilities in the conference, leave the conference to deal with all of that, and that just cannot be the way that this is going to play out moving forward. And so let me get to the last slide.
And if you need more time, I don't want to rush anybody. I want everybody to be able to present their
Sure, and I hope this won't be my only time to address the court this afternoon. I understand there's multiple people. We'll sort of pass the mic around, but there's certainly a lot more I want to say. So the last slide basically summarizes what we're asking for by way of our preliminary injunction, Your Honor. What we are asking for is no more than trying to validate our rights under the bylaws and to prevent the departing schools from trampling on those rights just because they outnumber us 10-2. And I think it's also important to remember, Your Honor, that the relief we are seeking in this case, which is that we should be recognized as the only two members of the board, as the bylaws dictate, and as everybody understood for more than a year. That relief is the direct result of the actions of the departing schools who chose to prioritize their own self-interest over the interests of the conference, and they did so knowing full well what the consequences to them would be, because they imposed those exact same consequences on USC, UCLA, and Colorado when they all announced that those schools announced that they were going to leave. So they made their decisions knowing exactly what the consequence would be. So for them to come in and say that this is unfair to them, that it can't possibly be the case that these two schools are the only two board members, it's not only what the bylaws require, but it's what they knew the bylaws required, because they adopted and ratified that interpretation more times than I can count, frankly. So so that's what we're asking for. Happy to answer any questions. Also happy to talk to Your Honor in a few minutes.
Sure. You said that you didn't see any point of continuing the hearing for more time for mediation.
You know, Your Honor, I think we're at a point where the parties need to know whose interpretation of the bylaws is more likely to prevail in this case. I respectfully would submit that the irreparable harm to the plaintiffs, if we've demonstrated a likelihood of success, if we've convinced the court that our interpretation is more likely to prevail, which I respectfully submit we have, then the plaintiffs need to be empowered to act now and not later when it's going to be too late. I think the irreparable harm is actually an easier question here, both because under the law, it's just clear that the loss of governance rights is irreparable harm, but also given the critical time period that the conference finds itself in right now. So I think the parties are at a place where they would benefit from judicial guidance on whose interpretation is more likely to prevail in this case, and then that could potentially help. I don't know. I don't make all the decisions, unfortunately.
Okay,
Thank you.
Appreciate that. All right, so now we'll take us to Pac-12 Council.
Good afternoon, Your Honor. Before I make a few brief points in support of the conference defendants' positions, I would like to update the court on the current state of conference operations since the September 11th TRO hearing. This is important to both motions before the court today, although I note that we are focusing on the preliminary injunction motion. To begin, since the court entered the TRO, which allows the conference to carry on its business in the normal course and to take other actions for which there is unanimous written support of the members, the commissioner and the conference have achieved the following vital actions. After the September 11 hearing, in fact the day after and the day before the disputed board meeting, the commissioner secured unanimous support from the members on the employee retention plan that I discussed with the court on September 11. That happened a day after the meeting. Within a week of a day after the hearing. Within a week of the hearing, the commissioner secured the unanimous written support from the members on the scope of services plan. The commissioner intended for this plan to streamline the business and to preserve optionality for Washington State and Oregon State as the remaining members. And since the hearing, with its workforce intact, the conference has been able to perform the obligations that are essential to driving the business for the benefit of all members. The conference has been able to maintain productive neutrality in operating the business of the conference while the members work to resolve their differences in and out of the court. Since the outset of the litigation, and even in the weeks of chaos leading up to it, the laser focus of the conference and the commissioner has been the orderly and sustainable conduct of conference business, maintaining its critical workforce, defining the scope of its services to meet present challenges, and the successful performance of conference business to maximize value and to support competition among member teams and athletes. The TRO preserved the status quo that has allowed the conference and the commissioner to succeed, and all members have enjoyed the benefits of a successful fall season of Pac-12 action. the conference and commissioner are concerned that the outcome of the PI motion will disrupt that, as the new interim order sought by plaintiffs will likely throw into chaos the operational status quo that preceded this litigation and continued under the TRO.
Why do you say that? Why do you say it would be in chaos?
I think the key is the conference and the commissioner are neutral on who the board is.
Right.
What the plaintiffs don't address is they don't address what they plan to do. There's no agenda for that first planned board meeting. We don't, and it's something that the plaintiffs have not addressed, and it is a grave uncertainty, I think, that causes a great deal of consternation among the members. What is going to happen when that shift of if that shift of power is given in a preliminary hearing? We don't know what they'll do. They seem to accuse each other of taking all the money and icing the group without the power out of the benefits of the conference, and that is the chaos that it would lead to. We're concerned about interlocutory appeals, collateral litigation, and the other kinds of chaotic actions that make performing the conference's daily, weekly, monthly action for the remainder of the 23-24 school year. There's going to be a Pac-12 championship football game that needs to be produced on December 1st. There's a Pac-12 basketball conference in the spring. All of these things are very important revenue-producing events that stand to benefit the entirety of the conference.
Do you think that if the plaintiffs obtained the two board positions, they would in any way affect the future sports that have been scheduled?
I don't know. We don't have an agenda. We have no idea. We have fear, uncertainty, and doubt from both the departing schools on the one hand and the plaintiff schools on the other. And what our main point today is that the court listened very carefully to the parties on September 11th, decided that that order would preserve the status quo as the law requires in a circumstance like this. And in the 9 weeks since that time, business has been conducted, revenue has been generated through the performance of the conference's obligations to its contracting partners and others. And in that course of 9 weeks, nothing has changed. And yet the plaintiffs want a new order. And I think that is another thing that is of concern to us, is that we don't see what has changed in that time period, and the uncertainty about what their first action will be and what their second action will be, not because we have a horse in that race. It's just that we have to carry things out and get work done while the consequences of those actions are litigated and disputed between the disputing members. That is the concern. And we think that the conference and the commissioner believe that a lot can be lost, which is the subject matter that's being fought over here, if those disputes are too disruptive and too dislocating.
Does the Pac-12 want to continue in its business in the future? Frankly, that is up to Oregon State and Washington State at this point. And the conference and the commissioner are sensitive to those issues, and also sensitive to the notion that without a board, that makes things difficult. But we think that the status quo and the TRO does facilitate both, on the one hand, preparation for a trial that could lead to a final judgment, but hopefully in the interim of that, looming under that shadow, a resolved dispute through further discussions of the parties. We think that is the best way for the most members, and certainly for Washington State and Oregon State, to have the clearest and smoothest future. But that's in some ways, that's the extent of what the conference and the commissioner have to say here today about the event that's before the court, which is to change the TRO provisions, which were really important, allowed the conference clearly to continue in the normal course, which includes communicating with its constituent members, listening, explaining things, providing information, not deciding things that would require a board. Obviously, you can't do that, but there's a certain functionality that the conference and the commissioner need in order to serve
the interests of the members. And the members have interests whether they have a board seat or not for the remainder of this school year. And we realize that there are many disputes over assets and revenue and things like that. But we think that discussion, dispute resolution among the parties is the better way to do that than through an alteration of the TRO to put in place what the plaintiffs are seeking here.
Okay, so the Pac-12 is satisfied with the TRO and basically wants that TRO extended pending further negotiations or subsequent litigation between the parties.
That is our preference.
Okay, gotcha.
I sense that there may be a fair amount of arguing from the table over here to my left. I'm happy to address a few additional points, but really my main legal point, it is a legal point too, not just a pragmatic point about maintaining the status quo. And while on the one, I understand the plaintiff's argument is that the status quo is a board of Washington State and Oregon State because the bylaw, by their interpretation, is self-executing. I understand that logically, but what it does is that making that determination at a preliminary injunction stage it empowers them to change the status quo in a variety of ways. And again, we're somewhat agnostic to what they would do. We just don't know what it is. And if it's something drastic, we think that the ensuing dislocation hurts the conference, hurts the members by virtue of that.
All right, thank you, counsel. Mr. Randall, sir, thank you for that argument. All right, so next up will be the intervener, University of Washington.
Thank you, Your Honor. Daniel Levin on behalf of the intervener defendant, University of Washington. And thank you for giving us the opportunity, Your Honor, to speak with you this afternoon. And I'll try to stick to the 20 minutes.
Well, I think we already went past that, so I think we pushed that to 25 already. So
Thank you, Your Honor. I'll try to keep my eye on the clock.
All right.
Your Honor, preliminary injunctions are about preserving the status quo, but plaintiffs are asking this court to change the status quo, to hand them control of the conference right now when the University of Washington and the 9 other members who will be departing at the end of this year are still full members of the conference, are still competing on the field and on the court, and are still critical to the conference earning revenue this year, which all of the schools use to support their student athletes. This is not about making decisions for the future of the conference. When the University of Washington told the conference about its future plans, it said in that letter sent on August 4th that it understood it would be excluded from conference discussions pertaining to the future, in particular a new media rights deal or talking with new members. What this is about today is control of the board this year, and in particular control of the conference revenue this year, which is being earned by all of the schools competing, and which all of the schools rely on to support their student athletes across the whole range of revenue and non-revenue sports. What the plaintiffs are asking for is not fair. It threatens to irreparably harm the University of Washington and the other 9 departing schools, and it's not what the bylaws require. So I want to start, if I may, Your Honor, with the bylaws. They're a contract, and so we should start with the text of the contract and its history. Then I'd like to talk, if I could, second about the course of performance argument and why the actions over the last year don't support the plaintiff's position. And then last, I want to turn and talk about the equities, which we feel do not support the entry of the requested preliminary injunction. So, Your Honor, if I may, I'm going to hand out, I just have one slide with the bylaw chapter 2.3 on it that I just thought it would be helpful to have in front of us when we talk about the bylaws. May I approach, Your Honor?
Sure, you bet.
Thank you.
Counsel, all right.
And Your Honor, I want to start and talk about the text from the beginning to the end and how it all works together and how it doesn't do what the plaintiffs say it does. So let me start with that first clause. No member shall deliver a notice of withdrawal to the conference in the period beginning in 2011 and ending August 1st of next year. That period is significant because it relates to the media rights agreement that the Pac-12 has. And when you read this entire provision as a whole, the main thing that it does is make sure that members stay within the conference for the full term of the media rights agreement. And in fact, it gives the conference the right to go out and get an injunction to keep schools in the conference until August 1st of next year so that the conference doesn't breach its media rights deal. So the question is, what does this period mean? What does it mean to say you can't deliver a notice of withdrawal in the period beginning July 24, 2011, ending August 1, 2024? And we submit that it means that you cannot tell the conference that you are leaving in that period. You can't tell them with a year notice. You can't tell them today that you're walking out the door, tomorrow. But what you can do, and what no one in this case, as far as I can tell, disputes, is you can leave on August 2nd, 2024. That is, no one has said the University of Washington or any of the other departing schools is in violation of the bylaws by leaving on August 2nd. And that's important. I'll get to that in a minute. But I want to go then to the next clause, because counsel for the plaintiff said, well, that's about something different. That's about leaving in the prohibited period. And I agree. It is about leaving in the prohibited period, but it's not separate and distinct, because the language doesn't support that. So look at what it says, Your Honor. It says, provided that if any member does deliver a notice of withdrawal prior to August 1 in violation of this chapter, the conference shall be entitled to an injunction or other relief to prevent such a breach. The breach there is obviously leaving before August 1. It cannot possibly be saying before August 1 that you are going to leave in the future. That injunction wouldn't make any sense. What are you going to enjoin? That you can't talk about it anymore? You have to do a take back? It's not. The only plausible reading of that provision is that the breach is leaving before August 1. So maybe you've announced, if USC and UCLA had announced last summer they were leaving in 1 year, that would have been a breach because it would have been a 2023 departure. If you announce you're leaving after August 1, 2024, not a breach, not a violation. Provision goes on and talks about an alternative remedy that even if you try to leave, withdraw, or attempt to withdraw, the conference keeps your media rights. Makes it very hard to leave. It also means the conference can satisfy its obligations to its media partners. And then we get to the last sentence, and it says, in additionally, if a member delivers a notice of withdrawal in violation of this chapter, you lose your board seat. So what does that mean? What is the violation? Well, Your Honor, I submit it's the same as the breach from the second clause. It is a withdrawal, or the announcement of a withdrawal, before August 1, 2024. That reading harmonizes the entire section. Every clause works together. It's not that the center clauses are about something totally different. They're all about the same thing. And they're all about keeping members in the conference during the term of the media rights agreement. And I would contrast that, Your Honor, to the pre-2011 bylaws. Because the pre-2011 bylaws did something very different. They said, you must give notice. 2 years in advance. If you want to leave, you must give notice. And when you do, you lose your board seat effective on the day you tell people. And it said that clearly in that prior version. All of that language came out. That is, they got rid of this prior notice requirement. And they got rid of that language that said, effective on the date that you deliver this notice, you lose your board seat. They changed it. And they changed it instead to have this protected period from 2011 through 2024, which corresponds to the media rights agreement. So I think it's very hard to look at the history and the change from 2011 to the current bylaw and say it supports the plaintiff's reading, when in fact the prior bylaw was clear that if you gave notice, and you were required to do that, you were off the board. The difference between having that requirement in the current bylaw is that under the current bylaw, where there is no withdrawal pre-announcement requirement, there's no requirement to give a 2 years notice on a withdrawal, it would be encouraging subterfuge. That is, it would be encouraging people to keep their plans secret for as long as possible so as not to be in violation of the bylaw.
Or would that help the conference not having any notices on we're leaving? And doesn't that damage the conference by just having a team or a school, I should say, university say we're going to withdraw on August 1st, 2024?
Well, I don't think so, Your Honor. I don't think it helps anyone to have a school have a plan to leave in 2024, but to keep that secret, because it says giving notice and publicly announcing in some form to the conference. And if you're encouraging people, they want to keep their board seats, to say, we're just not going to tell anyone. That's not a situation you want to have. Now you have board members who have plans that you don't know about. It makes it very hard to plan for the future. It makes it hard to decide about future media rights deals and so forth. You certainly don't want a situation where you have schools that have made a decision but are incentivized not to tell anyone about it, which is the upshot of their reading. And what we'd say is that is not a reasonable construction of the paragraph to say they wrote something that took out that notice requirement, took out that 2-year notice requirement, and still meant if you tell people about your future plans, which all of the schools did because it's the right thing to do, that you then automatically lose your board seat. It's not what the provision is designed to do anymore. That was the prior provision, but it's not the current one. The other thing I'd say, and which the conference pointed out in one of its papers, is it does lead you down the road to a board of 0. And we all know from the evidence in the record that Oregon State and Washington State did pursue other conference opportunities. Now, they haven't yet found another conference opportunity, but they did pursue them. And if they had decided to leave, there would be no board under this provision. And their answer is, well, in that situation, sort of everyone comes back on and does something. But that's not at all what the bylaws say. That would just be writing a new provision into the bylaws to say, well, at some point when everyone's kicked off, everyone just comes back on. And that might be fine, but it's not what they wrote.
Would the Pac-12 be able to file a petition for a dissolution and move forward that way without? We lost all our board members, so we're petitioning the court for dissolution.
I don't think so, Your Honor. It might be able to do that, but I don't think so because there's actually a bylaw provision, 1-4, that deals with dissolution, and it gives the board a role in that dissolution in terms of deciding how assets are distributed. So there was a contemplation that the board would play a role in that. There's no contemplation in the bylaws that the organization could ever have a board of 0, and there is a provision that says the board directs the operations of the Pac-12. So there's no contemplation anywhere in the bylaws that there could be a board of 0. Again, it is the inevitable outcome of the plaintiff's interpretation of the bylaws to say, as soon as you tell people, as soon as you announce it, you lose your board seat. The other part, they say, well, it's because this is dealing with conflict of interest, right? Their argument is, well, you need to have this automatic expulsion. As soon as you've announced you have another intention, you have a conflict of interest, and therefore it makes sense to kick you off the board. And Your Honor, what I'd submit is, no, having announced your future intention does not mean you have an intractable conflict any more than it meant than the plaintiffs had an intractable conflict when they were talking to the Big 12 or the ACC or any other conference and trying to get a bid to join one of those conferences. That's not an intractable conflict of interest. All of the schools have an interest in their own student athletes. They all have an interest in promoting their own programs, and yet they all have a duty when they sit as board members to act responsibly in the service of the conference and all of the schools together, which they have done for years and years and years, even when schools disagree, and even when one school might have different interests or even interests that are aligned with their own school as opposed to other schools. So there's not a reason to say it's impossible for these schools to serve on the board. And in fact, that's why the University of Washington recognized when it said it was leaving that it would not participate in decisions about adding new members and that it would not participate in decisions about a new media rights deal for next year because it understood that those are decisions that are best left to the 2 schools that are currently remaining. So let me turn now to this course of dealing, and I do want to be conscious of the time.
You've got time.
Oh, great. So let me make a preliminary point about the course of performance, a legal point, and then I want to talk about the facts on this. And there's two legal points I want to make. The first is, and we cite this case in our brief, and it's essentially unrebutted, is that what the California Supreme Court and Washington law have both said is that this type of course of performance evidence applies when parties are not in a dispute about the meaning of the contract. That is, when pre-dispute, if all parties to a contract all see it the same way, then it is important evidence. But that's not at all factually what happened here. All of this, all of their evidence is under the shadow of a dispute, all of it. That's one. The second legal point I want to make is...
Well, there wasn't any dispute until USC and UCLA announced they were leaving, right? I mean, that's when...
It came up in the context of a dispute, Your Honor, is what I'd say. There was no one... there's nothing in the record to say anyone had given any thought to this until USC and UCLA announced. And what happened was the conference, general counsel sent a letter a few days later on the 4th of July saying, we think you're off the board. USC and UCLA immediately responded and said, we disagree. We don't think you're reading this right. We think we're still on the board. Now, they didn't sue. And they didn't try to barge their way into the meeting, I guess. But they clearly disputed it. So we do think that all of this whole course was there was a dispute going on. And it's true that University of Washington and others attended board meetings during this period that UCLA and USC were not at. But the board itself never took a vote. It never adopted, it never said USC and UCLA are formally expelled. It did go on and talked about the future in those meetings. And it went on. And then there was another letter to Colorado. We understand that's in the record. And again, Colorado disputed it. So we're still under the umbrella of a dispute. And then eventually we get to the point where the conference realizes it is on the road to a board of zero and it is on the road to chaos. And it changes, frankly, its position and says we aren't so sure anymore about what this provision means. And its current position is I believe, that this is something that should be left to the parties and to the court. But all of the course of dealings is under the shadow of dispute. In all of the course of dealings, it does not unequivocally say that everyone understood the bylaws that way, because I would submit that Oregon State and Washington State, there's evidence that they didn't understand the bylaws necessarily that way. And I'd point to Exhibit 15 of the Heck and Lively Declaration that we submitted, which is a letter, maybe it's an email, from the lawyer at Washington State, Mr. Dean, to the general counsel of the Pac-12. This is in August of 2023, August 5th, the day after 5 schools announced they were leaving. And it says, has any school, including USC or UCLA, delivered the conference what you would consider, or what could arguably be considered, a notice of withdrawal under the conference's constitution and bylaws? Has anyone done it? On August 5th, 2023, more than a year after USC and UCLA left, USC and UCLA have not been sitting on the board, but the lawyer at Washington State says, has anyone done this? That is evidence that people were not thinking about this in terms of everyone was in agreement that there had been a breach of the bylaws by USC and UCLA. It's true everyone realized they weren't there, of course. They weren't in the room. People understood that. There were meetings. They weren't there. But there's evidence that people didn't understand it this way until we got into litigation and everyone started pointing fingers about who said what when. And my point, Your Honor, is that ultimately this comes back to what is the most plausible and sensible reading of the text. The behavior over the last year, I don't think points one way or another. I don't think it helps illuminate the question. I think the question is, what does the bylaw mean? What did the parties intend? Is it a reasonable construction to say it prohibits departure in the prohibited period? Or is it a reasonable construction to say, no, it prohibits talking about departure in the prohibited period? And we'd submit it's the former. I'd also say, and Your Honor asked a question there about USC and UCLA. The board took no action against USC and UCLA. And as Your Honor noted, there is no liquidated damages provision. There is no penalty. There is no exit fee in the bylaws. There is a provision about penalties. There is no exit fee. We don't believe the penalty provision has been triggered in any way. Obviously, if there's a board of 2, we would be very concerned that they could try to extract penalties. Let me turn, though, finally to the balance of equities question. And as I understand the record, there has been no real evidence submitted about what the plaintiffs intend to do when they take over the board. But instead, they've said it is irreparable harm for us not to control the board because we think we're allowed to control it. It's irreparable harm if we're not allowed to control it. Your Honor, one, I'd submit that that is not what the wisdom case that they cite says exactly. It says that it may, if you have a bargain for minority right, the Second Circuit in New York said it may be irreparable harm in some circumstances. Doesn't say automatically that's irreparable harm, and we do address that in our brief. It's on page 25. It is the end, but we do address it. But let me talk a little bit about the record shows in terms of actual harm that will take place with a two-member board that has made, as far as I can tell, no commitment to equitably distribute revenue, as has always occurred in the past and as the executive regulations, Section 1, require. They have said they would like to set aside money for liabilities, and I'll talk about liabilities in a moment, and they've said they would like to try to recruit new members, including presumably by paying them this year's revenue money. That is, paying the Mountain West teams to leave that conference, to break up that conference, and join them in a new Pac-12. Those actions, taking conference money, spending it on other teams, would irreparably harm the University of Washington. We put in evidence of that. We've put in declarations showing what the University of Washington spends the money on. They spend it on their student athletes. They spend it on scholarships. They spend it on counseling. They spend it on academic support. They spend it on their programs that are non-revenue sports. They spend it on the teams that are still to compete in the winter, in the spring. That's the state of the record. And with no guarantee of that money being equitably distributed, that is a real threat of irreparable harm to the University of Washington and to the other departing schools. And the other thing I would say, Your Honor, we are aware, and it happened after we filed our brief, but there was the University of Oregon State submitted a presentation to the Oregon State Legislature about their plans, and I have a copy of it if Your Honor would like. But if I may approach it, I'll send it to everyone. Yeah, Your Honor, I'll represent to the court that this was on the Oregon State University webpage, and I believe it was part of a November 7 presentation to the state legislature. And I would only direct your attention to page 3 of the slide, where Oregon State is still showing its budget for this year, $40 million plus of Pac-12 money. Your Honor, and that gives us a serious concern that there's an intent to distribute money to them and not to the remaining members. And we would submit that would be enormously unfair. It would be a violation of the current bylaws, a clear violation, which say that money needs to be distributed pro rata to all 12 members. And we've heard nothing to say from any of the plaintiffs that they have other intentions. So, Your Honor, let me finally turn to the remedy. And, Your Honor, we think the preliminary injunction should be denied. But if Your Honor is worried about going that far, we would have two suggestions. One would be to keep the TRO in place until there's a final hearing on this. And a second, Your Honor, would be to do what essentially the University of Washington committed to doing when it first announced its future plans, which is to say that it should have a voice and the departing school should have a voice in decisions about this year and about how the money is distributed this year, about how it's spent responsibly. And the decisions about a future media rights deal or about admitting members next year should be in the hands of the departing members.
Let me just ask you a question. You mentioned that the court could consider keeping the TRO in place until a final hearing. How far out how do you perceive a final hearing in this?
I mean, Your Honor, I think what we would be prepared to do at a final hearing is talk in a little more detail about what the actual plans are and what the actual harms are, which we have not really seen any evidence of. obviously we would be prepared to move quickly to a hearing. We're not going to ask for a huge long period of time. We certainly aren't going to stand in the way of getting efficient relief.
Okay, gotcha.
And Your Honor, you did ask about more mediation or settlement. So let me just say, I believe the parties have worked in good faith, all the parties in the mediation. We've not been able to reach a resolution, and I think at this point I'm not sure, and I heard what Mr. McMichael said, and I'm not sure that additional days would meaningfully move the needle. Thank you, Your Honor, unless you have other questions.
All right, thank you. I'll be back with questions. All right. I'll hear from the amicus curiae, Mr. Levin.
Your Honor, I think I've covered all the points from the amicus. I don't need additional time for
All
this.
right, this is all right. All right. Well, then we're back. I thought there'd be more time burned up, but all right. We're back to the plaintiff's counsel, Mr. McMichael.
Thank you, Your Honor. I'm happy to address any questions the court has after hearing from the departing schools. Otherwise, I'll try to respond to what I think were the key points that I heard. So I heard the counsel for the departing schools saying that the prior version of the bylaws, that there's nothing in there that is supportive of our interpretation of the contract. So let me just show you exactly the words. So if you could turn to page or slide 12 of my presentation, Your Honor. This is what was previously in the bylaws prior to 2011. This is the section entitled withdrawal. And the way it was set up was very clearly you had to provide a notice of withdrawal before you actually withdrew. So that term, Your Honor, notice of withdrawal, had a clear understanding under the prior version of the bylaws, which was a notice prior to an actual withdrawal. And then it had a sentence that said, effective on the date that you deliver the notice of withdrawal, you are off the board and can't vote on anything. And the significance of this, Your Honor, is twofold. One is because they took that exact same term, notice of withdrawal, and they carried it forward into the current version of the bylaws, and they said the breach is if you provide a notice of withdrawal prior to August 2024, it makes no sense for them to say that that phrase now has a different and new meaning than it did before. By choosing that phrase, they clearly were intending to keep the same meaning, which is it's a notice of withdrawal, not an actual withdrawal. Their interpretation is that literally the phrase notice of withdrawal, those three words meant one thing under the prior version of the bylaws and a completely separate thing under the new version. The other problem, Your Honor, is that their interpretation would represent a monumental departure in the prior version of the bylaws as compared to the current version, because it would now suddenly allow members who had announced that they were going to leave and join new conferences to stay on the board. There's no dispute that under the prior version of the bylaws, if you provide notice that you're going to leave, you're off the board that minute, because that's when you have a conflict. Their interpretation is that the new bylaws changed all of that, and suddenly everyone decided that they wanted conflicted board members who had announced that they were leaving to now stay on the board. There is zero evidence in this record that they have put forward to suggest that that's what anyone intended, what anyone understood. So they are proposing a monumental departure in the meaning of these bylaws with no evidence to support it. And when you line up the language in the prior version with the language in the current version, which is on slide 13, Your Honor. On slide 13, what we've done is we put directly on top and on bottom. The top half of the slide is the last sentence in the prior version of the bylaws, and the bottom half is the last sentence in the current version of the bylaws. And what you can see is that these two sentences are remarkably similar. They both say that if you provide a notice of withdrawal, you are automatically off the board and you cannot vote on any issue before the board. So their argument that the new bylaws meant to change and disrupt all of this, first of all, there's no evidence to support that, but second of all, it cannot be reconciled with the fact that they kept essentially the same language in that sentence. If they were trying to represent a monumental departure from that rule, they really did a poor job of revealing that. Let me take now head on this idea about this conflict of interest, which we represent and submit that this remedy is intended to, that this language is intended to remedy. The departing schools have no good answer to the argument that they can no longer be on the board of the Pac-12 because they are now under a conflict of interest and have no loyalty to the conference. As I understand their argument, they're basically saying, Your Honor, that the court and we should just trust them to tell us when their conflict allows them to vote or when it doesn't allow them to vote. But there's several problems with that. One is, it's not what the bylaws say. The bylaws say if you provide notice, you cannot vote on any matter. So this whole idea that, oh, they'll just recuse when they think there's a conflict for them is completely anathema to the bylaws, which say you cannot vote on any matter. And that's exactly how this was applied against USC and UCLA, and I'm going to get to in a second, with the full knowledge of the University of Washington and everyone else for over a year. You don't vote on anything. There's no hybrid model where you can recuse but still vote on some things. If you care about those things, that's not it. The other problem with this argument is that it presupposes that there's some clear demarcation between decisions that only affect what happens in the next 9 months versus decisions that only affect what happens after August 2024 when they're going to be gone. But there is no such delineation. As is true in any organization, decisions you make in the short term will have a significant impact in your future, and frankly, whether you're going to have a future. So to take one example, the University of Washington has argued that the decision about what to do with the net revenue over the next 9 months, that's a short-term decision, and they should be entitled to vote on that.
Well, tell me, what would be the plan? What are the plaintiff's intentions?
Yeah, Your Honor, the plaintiffs have been very straightforward, which is we don't have a plan yet. What we want to do is to try to become the board and try to chart a path forward for the conference. We have no secret plan that we are sitting on that we haven't disclosed to anybody. So it's not like we're being coy about this. We are trying to explore all options. We have many people working a significant amount of time trying to figure out what those different options are. But we can't do anything right now because we're shackled to 10 people who have no interest in seeing this conference survive or move forward or even have a future. All they want is to get every last dollar that they can out of the Pac-12 before they leave and join the Big Ten, the Big 12, or the ACC. So we can't do anything in this state of paralysis that we're currently in. And that's why the TRO is fundamentally no longer workable for the plaintiffs. I think it was very clear when I was last before you and the court was ruling on the TRO that the counsel for the Pac-12 stood up and said that there were a couple of short-term decisions. They really wanted to not see those short-term decisions get thrown off the rails. And so we agreed to address those specific issues, that we would allow unanimity to address those specific issues. But I think it was understood, at least by me and I think by everyone else in this courtroom, that that relief was intended to get us to a preliminary injunction hearing where we could decide, based on a more fulsome record, whose interpretation of the bylaws is more likely to prevail. That's the likelihood of success prong. Then we get to the, will we suffer irreparable harm if our governance rights are trampled and the 10 dominate the 2, not because they're right and not because they have any entitlement to vote, but just because they're 10 and we're 2. That's the irreparable harm prong. So I do not think that the TRO is workable, and the reason that they're arguing for it is because they know that they're 10 and we're 2, and they can simply stop us from doing anything to try to save this conference. If the unanimity requirement continues on, we can't spend $1 on the Pac-12's future unless they agree to it. But they've already made their position very clear. Don't spend $1 trying to regrow this conference. Don't spend $1 trying to plan for the future unless you give us the same exact amount of money. So this whole notion that we can't spend money unless it benefits them pro rata is just fundamentally illogical, because what's in the best interest of the Pac-12 is completely mutually exclusive with what's in the best interest of the 10 who are leaving. So that's why I think there needs to be clarity on, under the bylaws, who is entitled to be on the board. Your Honor, this suggestion, and I gotta say, it was a very well-delivered argument that I heard from Mr. Levin about the bylaws and how this just doesn't make any sense. But I just cannot help myself to say, if that was the interpretation, why did the University of Washington and 8 of the other 10 departing schools and the conference take the exact opposite interpretation, our interpretation, for more than 13 months. They just cannot give you a good answer to that. So instead what they try to say is that, well, all of that evidence is not really relevant because it's occurred after this dispute began. That's what they say. But they're conflating two completely separate disputes in an effort to try to sweep all of that evidence under the rug. The dispute that brings us here today in court is a dispute between Oregon State, Washington State, and the conference and the departing schools. That's the dispute we're here before today. That dispute did not begin until September of this year, when the conference suddenly reversed its interpretation of this provision, no doubt at the urging and at the behest of the 10 departing schools who were leaving, who suddenly no longer liked that interpretation. That's when this dispute began. But all of the evidence that's laid out in our presentation about the board, about the conference, consistently adopting our interpretation time and time again for 13 months, all of that preceded this dispute. And it wasn't like those interpretations, Your Honor, were some made-for-litigation contrivance. It wasn't like it was some kind of settlement communication or pre-litigation dispute. The interpretation that we are advocating for here today was the interpretation that the conference and the 10-member board used to govern itself for more than 13 months to make many significant decisions that had real-world consequences. This was not a made-for-litigation interpretation. This was how the conference governed itself for 13 months. That is textbook course of performance, and that means that our interpretation is right and their interpretation is wrong. And they're also wrong, Your Honor. Sorry.
Go ahead.
Okay.
I've got my list, 4 pages of questions.
Okay. No. Let me stop. Sorry. I sometimes get ahead of myself. So please, I'm happy to answer any questions the court has.
Passionate argument. So, question: are the plaintiffs really claiming that by losing their seats on the board, those 10 other universities are forfeiting their share of proceeds for this year held by the Pac-12?
No, Your Honor, we're not saying that by virtue of the fact that they have announced their withdrawal and that they've been removed from the board, that automatically triggers a forfeiture of any remaining revenue. No decisions have been made by OSU and WSU about how resources are going to be allocated and to whom and in what manner. We will make reasonable decisions as board members that are in the best interest of the Pac-12, not in the best interest of any one individual member. That's what any board member is supposed to do. So we're not saying that they automatically lose their money, but it's actually funny that you raised that question, because if you look at slide 32, Your Honor, please. This was a memo summarizing a board meeting that occurred between July 27th of this year and August 4th of this year. So this was after Colorado announced on July 27th that Colorado was leaving. And let me just walk you through that just as one example. We have multiple examples of this playing out in the presentation, but let me just give you a flavor of this, Your Honor, so you can get a feel for the evidence. If you look at slide 29, and I can do this very quickly.
That's right.
Okay, so slide 29 is a July 27, 2023 text from Chancellor DiStefano at the University of Colorado to the commissioner saying, just so you know, later today our board is going to vote to join the Big 12 in August of 2024, which is what they announced. So he just texted him and said, we're going to leave. So here's what happened, Your Honor. If you look on slide 30, that very same day, the 9-member board of the Pac-12, which included the University of Washington, included 8 other members, included the conference and the commissioner, had a board meeting. And what the board members were told is that CU has provided formal notice of withdrawal. They were told in plain language that by saying that they were going to leave in August of 2024, that was, quote, formal notice of withdrawal. That means they adopted our interpretation. They told it to the 9-member board. Do you know how many of those members objected and said, we don't agree? That's not right? 0. No, and that's exactly the same thing that happened when USC and UCLA withdrew. The board was told in plain language, if you say you're going to leave, you're off the board because that's a notice of withdrawal. No one objected. They then talked to the board. The next bullet point is board of directors. Who is the board? Colorado was not allowed to attend a single board meeting from this point forward. Again, they talked about it. They agreed on it. If you look at the next slide, Your Honor, slide 31, the very next day, the general counsel of the Pac-12, who's seated behind me, drafted a letter, sent it to the general counsel of the University of Colorado, and said, you have delivered notice of withdrawal, and under Chapter 2, Section 3, you are automatically off the board. Again, that's our interpretation of the bylaws, not theirs. And then if you look at slide 32, and this is where I began, the board then had a discussion about reducing the anticipated distributions to our departing members. That was Colorado, USC, and UCLA. It's not a coincidence that $105 million just happens to represent the sum total of the distributions for those three schools as anticipated going forward. And they also said that they're considering options, including seeking considerable financial penalties against them. This is what was discussed with the 9 remaining members of the board. And it's interesting because you could only be talking about penalties if these people were in breach of the bylaws, which would require you to take our interpretation. But it's also interesting because they're coming into court and telling you that it would be egregious and unfair if we reduced their distributions by $1, when apparently 9 of them had no problem with that concept when the roles were reversed. And this is just yet another example where the departing schools are taking a position in court that is directly contrary to the position that they took during the relevant time period.
Now, so your position that if the plaintiffs do something wrong, contrary to what the 10 other schools believe should not be done, they can sue WSU and Oregon State University for damage.
Your Honor, I have no doubt that if they think that they've been wronged or aggrieved in any way, or they think that they don't get all the money that they're entitled to, we will hear about it in court. And we will be in some court somewhere to deal with it. But that's not the issue that we need to deal with today. And this, again, is why we believe that these are all red herrings, and that's how we position them in our brief. And so if you turn to slide 47, this, again, is something that we anticipated, is they're saying they want to turn this into a discussion about what can we do as the board and what can we not do as the board. Not surprisingly, it all seems to revolve around money as far as they're concerned. That's not what is before the court today. What's before the court today is whose interpretation of the bylaws is more likely to prevail, and would we, Oregon State and Washington State, suffer irreparable harm if our governance rights are denied to us in violation of the bylaws. Those are the two issues before the court.
So I'm getting ahead of what you're saying is I'm getting ahead of what we're really dealing with today.
At their urging. I mean, that's why they want to change the discussion, sort of change the conversation to that, because when you look at the bylaws, when you look at their course of performance, and you look at the sort of undeniable fact that if our governance rights are stripped from us unfairly, that would constitute irreparable harm, then you need to have something else to talk about. And that's why they want to talk about, well, we can't do this. We've never said that we're going to distribute all the money to ourselves or do anything else that they're complaining about. All of that is speculation. All of it is just unfounded, sort of trying to ask the court to predetermine every possible future scenario, and I don't think that makes a lot of sense. What we've said is that we will make reasonable decisions. If they don't like our decisions, they'll have every ability to address them, but that's not what we're here to decide today. And I'm more than happy to answer questions. In fact, I really want to address whatever is concerning the court, because I
Sure. Well, would the relationship with the two universities remaining, the plaintiffs, would they have a fiduciary relationship with the 10 departing and vice versa?
I don't, that's a good legal question, Your Honor. I don't know that I'm the wrong one to answer that, but I don't know that in an unincorporated association like this, that the members necessarily owe fiduciary duties. But I think any board member has a duty to act reasonably to the association to make decisions that are in the best interest of the association and to comport themselves that way. Again, those are all legal issues that we can hash out down the road if we need to. But if you look at slide 48, and this gets back to something that I think the conference argued more than the departing schools, they're trying to say that we somehow are asking for a deviation from the status quo through this. That's exactly wrong, Your Honor. If you look at slide 48, for more than 13 months, the status quo was that if you provided a notice of withdrawal, you were automatically removed from the board that very minute, and the board would continue to meet and make decisions without you, and that was just a universal rule that this conference operated in for more than a year, with the knowledge, with the consent of all of the members. And that's exactly what our preliminary injunction seeks to do. It seeks to preserve the rightful composition of the board pursuant to the bylaws, no more, no less. And the fact that they want these modifications, they want to hamstring us and say you can't spend $1 if you're the board, which, by the way, there's no support in the bylaws for that at all. I think that just exposes their conflict of interest. They don't want the board or the conference to spend any money on the conference's future because their futures are no longer tied to the conference's futures. But that's not how board members are supposed to assess decisions as a representative of an organization, is what's in my best interest. You're supposed to focus on what's in the best interest of the organization. The last thing I want to say is this interpretation in no way encourages subterfuge or encourages people to keep their intentions secret. There are other provisions in the bylaws that say very clearly that you have to communicate in good faith and openly with your fellow members. So there are provisions in the bylaws that address this idea that you're going to keep, things secret. And frankly, I don't think it's realistic in today's world for a school to be able to negotiate with another conference and keep that a secret. So this idea that the bylaws are sort of encouraging subterfuge, I don't think makes any sense. What it's saying is that if you are going to leave, which you obviously need to tell us, then at that moment you have a conflict and you can no longer be on the board and you're automatically excluded. Exactly as it was in the prior version of the bylaws, with virtually identical language carried forward to the next version. And then the last hypothetical that they throw out, again, not the facts we're dealing with today, is what if Oregon State and Washington State provided a notice of withdrawal and you have a board of 0? Those aren't the facts today. We're not intending to go anywhere. We want to stay in the conference. We want to try to regrow it. So positing all of these possible future speculative scenarios and saying how that should affect today, I just don't understand. I think we should deal with the facts that are in front of us. And those facts are that under the bylaws, we are the board and we should be entitled to act as the board now and not have to wait for 9 months or 8 months when it'll be too late, and also not have to make every decision with their consent because we know exactly what that's going to result in. No money for regrowing, period, full stop. That's their position. So it's just not workable. I hope I've addressed everything, Your Honor. Again, I'm happy to answer any questions you have.
I think the questions I had probably don't apply anymore because they've been answered in one way or the other. I know there's a motion before the court to dismiss for lack of jurisdiction over the 9 schools in the Plain Sovereign community. Any mention on that?
Your Honor, I would defer to my colleague, Ms. Scavetti, if you have any questions on the motion to dismiss. I focused most of my energies on the preliminary injunction, but if you have any questions about the preliminary injunction, the motion to dismiss, she'd be more than happy to answer them.
Okay.
Thank you.
I'm not going to answer those. All right, counsel, appreciate your response to the court's question. How do you, what's your client's position?
Absolutely, Your Honor, and thank you for giving me the chance to address it. There is no requirement for the 9 other departing schools to be parties to this case under either CR 19 or the Declaratory Judgment Act. Under those provisions, a party is only necessary if its interests will not be adequately represented by the parties that are already in the case. And what we know about the 9 departing members' interests is that they want to see the case dismissed, they want the preliminary injunction denied, and I suspect if we keep going, they'll want to see the declaratory judgment that the plaintiffs requested denied as well. All of those positions are being adequately represented by the University of Washington and by the conference, which is moving to dismiss, opposing the preliminary injunction, and I suspect opposing the declaratory judgment that the plaintiffs are seeking as well. And in fact, the interests of the 9 members are being represented by their own counsel. Mr. Levin is the counsel for those 9 departing members, and he came up here and told you when we talked about the preliminary injunction that there was no additional arguments that he had to make on behalf of those 9 departing members. And their amicus brief says the same thing. It says they support and agree with the University of Washington's arguments. So what we have here, Your Honor, is a case very similar to the Wilbur case that we've cited in our brief. Now, in the Wilbur case, the issue there was a club that had decided to remove a pool that belonged to the club. And the issue was whether or not the club had the authority to remove that pool. So one of the pro-pool members of the club sued the club, seeking declaratory judgment and injunctive relief. And one of the anti-pool members intervened and said, Your Honor, you have to dismiss this case. They haven't joined all of the members of the club, and all of the members of the club have an interest in this pool. And the court said that's not required. There are only 2 positions in the case, is what the court said in Wilbur. Either the club has authority to remove the pool, or it doesn't. And those positions were both adequately represented by the parties in the case. And that's exactly where we are here. There are only 2 positions in the case. Either the bylaws mean what they say, that the members who deliver notice of withdrawal are automatically removed from the board, or they don't. And the University of Washington and the conference are here and able to articulate those positions. So those members are not necessary. And even if they were necessary, Your Honor, and we really submit that they're not, that their interests are being protected, dismissal for non-joinder is reserved as a drastic remedy to be exercised sparingly only when there's no alternative. And if the court can proceed in equity and good conscience without those members, then it is able to proceed and they're not indispensable. And we would submit that here, where their counsel's in the room, where they're aware of the proceedings, where they've had the opportunity to submit an amicus brief, that their interests are sufficiently protected and the prejudice to them is mitigated. Whereas on the other hand, if the court were to dismiss for non-joinder, then plaintiffs Washington State and Oregon State would have no opportunity to secure judicial intervention, to have the bylaws enforced and interpreted as they are written. And so in that case, the prejudice to us is substantially greater and the equities weigh in favor of proceeding, even without the 9 members as parties, but continuing to allow them to participate in an amicus capacity. And certainly if they wanted to join and intervene, they're welcome to do so.
Okay, thank you, counsel. I've been mispronouncing the word amicus all my life. All right. Let's hear then from that Mr. Lambert.
Very briefly, Your Honor. In September, I think one of my main arguments was that the record shows that this is very clearly a dispute among the members and that we are caught in the middle.
Absolutely.
We moved to dismiss the case because we were sued, and we don't believe that, and we believe that the complaint has some flaws to it, certainly with respect to us. I'll make 2 points on the motion to dismiss. First, the DJ claim under the Uniform Declaratory Judgment Act fails because the conference and the commissioner have no legal interest in the rights that plaintiffs seek.
Well, it sounds like they are not pursuing the Declaratory Judgment Act at this time, that they're simply pursuing or directly pursuing an equitable remedy of a preliminary injunction.
I understand the relief they want, the remedy, and a preliminary injunction, a permanent injunction, is a remedy, but it's not a cause of action. It has to be supported by a cause of action, and in this case, it's the DJ, it's the declaratory judgment claim. And my argument is that in the complaint, on the pleading, they seek a declaration that the presidents and chancellors of the schools that have delivered notice of withdrawal from the Pac-12 are no longer members of the Pac-12 Board of Directors and may not vote on any matter before the Pac-12 Board of Directors. The reason why that claim fails against the conference and the commissioner is that neither the conference nor the commissioner are on the Pac-12 Board of Directors, and neither of those parties has the right to vote. I think very illustrative of this is that even if the conference wanted to settle that declaration of rights, it has no power to alter the rights that are at issue in the declaratory judgment claim. We don't have the power under the bylaws to say who wins, to say who's on the board, who's not on the board. We've made that opinion in writing at various stages along the road, and things changed when chaos reigned. We don't run away from what we've said about this along the way. But for a declaratory judgment, seeking that declaration in a complaint against us, we think it fails the DJ Act. The Act requires that the claim is between parties having genuine and opposing interests. That's from the Osborne case. On that matter, the conference does not have genuine and opposing interests with the plaintiff. It's the unnamed members whose interests are at stake. They're here now. And we think that makes the conversation more coherent and the argument more pertinent to what's actually at hand. The conference and the commissioner are not the representatives in this case of any member. We've not been designated as members as required by law, and there's no evidence of a special trust relationship that we have a representative capacity with any of the members, whether they're on the plaintiff side of the V or on the defense side of the V, at least with respect to the members. So with that, and the last argument in a sentence, the breach of contract claim is based on that same declaration of rights. That's what they're seeking. They're seeking a remedy under the breach of contract to declare the board of directors, and for the same reasons that the declaratory judgment claim fails, we argue that fails again as a matter of law. And with that, I'll submit on what we've written.
Thank you, counsel. All right, we'll hear back from Mr. Levin.
Thank you, Your Honor. And I'm going to speak to the points about the preliminary injunction, and then my colleague, Mr. Hagen-Lively, will talk about the motion to dismiss for a few minutes, if that's okay.
Sure.
So let me start, and again, Your Honor, I'm happy to answer any questions along the way that I haven't answered. But let me start with the text in this question of the notice of withdrawal and what it means. And I want to start, too, with the prior version, because Mr. McMichael gave an eloquent argument about why, effectively, the new version kept intact the requirements of the prior version. And I would submit, Your Honor, that it just did not do that when you look at the actual words on the page. And I'm looking at his slide 13, but the prior version had a whole, and it's not on this slide, but the prior version began with the first sentence that said, you must give an advance notice. That sentence dropped out entirely, it's gone. And then at the end, it said, effective on the date that a member delivers notice of withdrawal, its board representation ends. That was the old version before 2011. It now does not have the prior notice requirement. And it now says, additionally, if a member delivers notice of withdrawal in violation of this chapter. And I understand the point that a notice of withdrawal could be a notification of a plan to withdraw. But I would submit that it is only in violation of the chapter if that plan to withdraw is before August 1 of 2024. And we know that from the rest of the text of the current bylaw. And if we look back at that text, if we look at that first clause, it says, no member shall deliver a notice of withdrawal to the conference in this prohibited period. It doesn't say, it does not link that to, it either, well, let me say it this way. You could read that to say it links delivery to the period or withdrawal to the period. But go on to the next clause, The next clause says, if any member does deliver a notice of withdrawal prior to August 1, 2024, in violation of this chapter, then there's an injunction to keep them in the conference. That clause can only mean, and I think I hear plaintiffs agreeing that this particular clause can only mean if you try to leave before 2024, August 1, 2024, you can be enjoined and told to stay. But if that's true, and I believe it is, I believe it's the only way to read that, then that's the violation. And then you go down to the last sentence. It is exactly the same language. Withdrawal in violation of this chapter. A notification of a future plan to leave after August 1, 2024 is not a violation of the chapter. It's not a violation. And therefore, there's not an expulsion from the board. Now, if you said, I'm going to leave during the prohibited period, and you gave advance notice of that, then this clause would apply. It's exactly what it would apply. But not if you say you're leaving after. So that's the textual argument. And let me then address this argument about there's no loyalty, there's a conflict. Because let's start, Your Honor, if I can, with the purpose of the conference, and it's right in the bylaws. Section 1, Chapter 1, Section 2. Chapter 1, Section 2. Two purposes of the bylaws. It says to provide, the purpose of the conference is to provide its members with a jointly governed body for sponsoring, supervising, and regulating intercollegiate athletics. And then B is to assist its members in funding and promoting their intercollegiate athletic programs. All 12 members have an interest in that conference purpose today. All the departing members will have an interest in that purpose up until the day they leave. The conference is organized for the benefit of its members. It's organized in order to put on athletic competitions and to generate revenue that supports each school's student athletes. And all of the members have an interest in that. And they will continue to have an interest in that until they leave. They are not hopelessly conflicted from all decisions, as the plaintiffs keep saying. They have an absolute interest in the purpose as reflected in the bylaws. So then let me turn to say to Your Honor's question you posed to the plaintiffs, which is, what is the plan? What's going to happen if they're given sole control? And Your Honor, what I hear them to be saying is, give us the keys, but we don't know where we're driving. We don't have a plan. And then when you asked, are you going to deny them any money? The answer was, we don't know. And then there was a long answer that says, but we absolutely have the right to do so. And in fact, some people talked about it in a memo back in August. I read that to say, good luck to the departing members. You may get no money this year to the detriment of all of your student athletes. And that, Your Honor, is not fair. It's inconsistent with the purpose of the association, and it would materially harm the departing members and frankly cause them irreparable harm. And it would not be in the interest of granting a preliminary injunction to do that. I would say one thing about that exchange of memos. The memo in which an individual at the Pac-12 suggested that there could be a penalty imposed, that is a memo from a government relations individual at the Pac-12. There's no evidence in the record that the board ever seriously considered that, and there's no evidence in the record that the board actually took any action with respect to any penalties as to everyone. And I would also say the penalty provision in 2-4 says any penalties have to be imposed pursuant to a discipline policy, which, Your Honor, does not exist. The conference has no discipline policy. It was never adopted by the board. So there's going to be, this is a road that no one wants to go down, or at least no one in the departing team wants to go down. But, Your Honor, it would be a disaster for the departing schools to get no revenue this year because it's being spent in the service of trying to convince Mountain West schools to jump ship and join the Pac-12.
So isn't the Pac-12 survival of utmost concern of all parties here?
All the parties want to see Oregon State and Washington State have a future. We're happy to see them have a future in the Pac-12 or elsewhere. But there's a difference between being responsible about the future of the conference, which no one is claiming that we're out to end the conference, and saying all of the money should be spent to that end and not to the purpose of supporting the current student athletes in the conference today. That's the fundamental issue, Your Honor.
When would distributions normally come from the Pac-12 for this year?
They normally come on a sequence. I understand that the ordinary first distribution would be in December. I understand that there have been times when they've paid an October distribution. They did not do that this year, and I think they would come in a cadence starting in December and then through the rest of the academic year.
So at this point, there hasn't been any distributions that have been stopped as a result of this?
At this point, no distributions have been made. There was no October distribution made, which I understand has occurred in some years, but there was none this year. But no money has been distributed this year.
Okay, thank you.
Let me turn for 1 minute, and then I'm happy to answer any questions, to this question of remedy. Because there was a lot of discussion from the plaintiffs about harms being speculative. That is, if we're excluded from the board, the University of Washington, the departing members, any harm to us is speculative because we don't know what they're going to do. That is what Oregon State and Washington State would do as board members. And Your Honor, my reaction is I think they have it backwards. Because the burden of proof is on the plaintiffs at a preliminary injunction hearing. And they have put in no evidence about what they intend to do. They've put in no evidence that anyone has stopped them from doing what they want to do because they can't say and won't say what they intend to do. And it's their burden to show that they have some harm, but instead what we're left with is speculating about what they might do other than that they say, well, we're not being allowed to run the conference as a board of two. And frankly, Your Honor, I don't believe that's enough to meet their burden of proof to get a preliminary injunction. They have to make a showing, and they've just put in no facts to show what they plan to do with the money. And so we're all shooting at ghosts, Your Honor, and I understand this is the home of ghosts. I'm looking forward to it, Your Honor. But my point, and I think it's apt, I guess, that we're here in Colfax to talk about it, is if you can't come in and ask a court to grant you emergency relief or preliminary relief without a showing of what you're actually going to do if you're handed the keys to the conference. So we'd submit on that, Your Honor, the preliminary injunction should be denied, and I'm happy to answer any remaining questions Your Honor has on that.
Okay. I had a list of 4 pages of questions, but your arguments and your points have taken most of my questions, answered most of my questions, so thank you.
Thank you, Your Honor. And I'll let my colleague, Mr. Hagenlein, if he can, just address the motion to dismiss questions.
Yeah, absolutely.
All right, thank you, Your Honor. I was hoping to work ghosts into my comments. I'm glad Mr. Levin figured out a way to do that already. I want to address the motion to dismiss that the University of Washington filed. And there's actually 2 issues. I understand that the declaratory relief claim is not being pursued at this time, so that drops us down from 3 issues to 2. I'll start with the issue that Your Honor raised, which is about the indispensable parties. The second issue is about the abstention doctrine. On the indispensable parties issue, counsel's argument appears to be that it's fine that the other 9 schools aren't here. We shouldn't worry about that because their interests are adequately represented by the University of Washington.
And the conference.
And the conference. I think that's a much harder argument for them.
Are they?
I don't think so, Your Honor. And I think that Washington law is pretty clear on this. Washington law, including the Matheson case that we cite, and the Angst case, says that if you've got a contract dispute, all the parties to the contract are necessary parties. They're saying that we're not necessary parties, that the departing schools are not necessary parties because they're represented by the University of Washington. And
if those parties have petitioned the court, like the University of Washington, move to intervene?
Could they, Your Honor? Sure, they could, but I think that would be intruding on their sovereign immunity. We have 7 of those 9 schools that are sovereign entities that are state entities in 6 other states. The whole point of this doctrine, and most of these cases involve tribes for a reason, is that those parties shouldn't be expected to have to come in and answer in the courts of a different sovereign. And with respect to the other 2 schools, that gets to all 9, they don't have personal jurisdiction in this court. They shouldn't have to subject themselves to personal jurisdiction simply because the plaintiffs chose this forum. And University of Washington is here. I think counsel's right. The outcome that UW wants is the same as the outcome that the other schools want. But this is not a case about a swimming pool at a country club, Your Honor. This is a much more complicated dispute where there are different facts that are relevant to each of the schools. I mean, Mr. McMichael's primary argument today, and certainly in their briefs, is about what happened after UCLA and USC left the conference and then, or announced that they were planning to leave the conference, and then what happened after Colorado did the same. Well, they can't seriously sit here and say that USC and UCLA weren't in those board meetings, but somehow took the same action to what they determined or what they say was ratify their removal from the board. And in fact, in the record, you see letters from USC and UCLA objecting and making the specific argument that they weren't removed from the board.
But
So
they let it go at that and didn't pursue any litigation, didn't really pursue any, come on, we want back on the board.
you're right, Your Honor, there was no lawsuit filed. As Mr. Levin said, the presidents and chancellors of those schools didn't barge into any of the board meetings that we saw on plaintiff's slides. That's right. But they said very clearly in their letters to the conference that we don't agree with this. And I think Your Honor saw that there's a reason why Mr. Dean and Oregon State's General Counsel as well were asking questions in August about has anybody delivered a notice of withdrawal. I think this issue was never settled. And their key argument is about what the remaining schools did after UCLA and USC stopped attending board meetings. They can't seriously say that USC and UCLA are similarly situated to those other schools with respect to those board meetings. And Your Honor, I think the case that's really worth focusing on here is the Automotive United Trades Organization case from the Washington Supreme Court. And both parties talk about that in our papers. That's another case where you had everybody that was argued to be an indispensable party. In that case, they were tribes. They were parties to a contract. It was a gaming compact. And the court said, of course, those are necessary parties. The only question is whether they're indispensable parties, whether we can proceed in their absence because they're sovereign and they don't have to be here if they don't want to. And the court looked at the 4 equitable factors that are laid out in the case law, and it said that every single one of those factors favored dismissing the case and determining that they were an indispensable party, except for the last one. The last one was whether there was another forum where the dispute could be litigated. And in that case, nobody identified to the court another forum where the case could proceed, other than the legislature. And the Supreme Court looked at that and they said, you know, I've read Marbury versus Madison. I know that if you've got an argument that the government is doing something unconstitutional, that's something that should be in court, not in the legislature. Well, there's no argument here of unconstitutional conduct by the government. What we're dealing with here is a dispute between members of a voluntary association. And in fact, there has been an alternative forum that's been identified. The conference identified the U.S. Supreme Court's original jurisdiction as the place where a dispute between states rests. And I think that's right. There are pretty clear cases that lay out disputes between states being within the original jurisdiction of the Supreme Court. Now, their argument is the Supreme Court could decline to exercise jurisdiction, won't always take those cases. That's true. But one thing I think is really important, Your Honor, is that this is not a dispute between 2 states that we're talking about. This isn't a river that's flowing from Washington into Idaho or Washington into Oregon, where there's 2 states. Maybe they could figure out that dispute on their own. We've got 6 different states. We've got a dispute between 6 different sovereigns. And respectfully, that's what the original jurisdiction of the Supreme Court is meant to address. It seems a little bit ridiculous to be talking about the Supreme Court dealing with questions about what's going to happen in college athletics. But I think this is a case where that is the right place for this dispute to be litigated if it's important for everyone to be present. The other argument
And just in your order, referring this to the Supreme Court.
I don't know if there's one of those in the file box over there, Your Honor. But
I can write one.
we wouldn't object to that. And what I'd say, Your Honor, is that the bottom line here is that we're talking about a remedy that the plaintiffs are seeking that's obviously going to affect the interests of the 9 other departing schools. We've got, according to the Commissioner's declaration, over $400 million in revenue coming into the conference this year. For all the reasons we're talking about in the preliminary injunction motion, that's money that the 9 departing schools that aren't here in court today are expecting to have distributed pro rata so that they can use it to fund their student athletes and all the programs that they rely on to put on sports, including the non-program sports. On the abstention issue, Your Honor, I think this is another independently sufficient basis for dismissing or at a minimum staying the case. There's been a lot of argument today about what's the right reading of the bylaws, who has the better one. We, of course, think that our reading is better. But in order to dismiss under the abstention doctrine, you don't have to agree with us. You don't have to think that our reading is better. The principle of these abstention cases is that if there's a voluntary association, unless they're doing something that, quote, plainly contravenes, close quote, the bylaws of the association, then it's for the members of the association to figure out amongst themselves. The court doesn't get involved unless what's being done plainly contravenes the bylaws.
And that's where the plaintiffs are claiming that the actions plainly contravene the bylaws.
That's their argument. And I think even if you don't get all the way towards accepting that our reading is better, I think at a minimum, I hope we've convinced the court that our reading doesn't plainly contravene what the bylaws say in light of the ambiguity. And what the case law says is that it has to be arbitrary or unreasonable to read the bylaws in the way that we're asking the court to read it. And I think we've crossed that threshold pretty easily, Your Honor. And I think the cases on this point, the argument on the other side is, well, this is an important issue. It goes directly to the governance of the conference. Surely the court should get involved. But that's the same fact pattern in the cases that we cite. And I think the California trial lawyers case is instructive here. That was a dispute about who was going to be the president-elect and then subsequently the president of the association. There was an argument by some members that the person had been appointed president-elect in violation of the bylaws. There was a dispute about that, and the court said, you know what, we're not going to figure this out. That's an issue. There's reasonable interpretations on both sides. We're going to let you all figure it out, even though it determines who's going to be the leader of the association. It's the same fact pattern here, and we think the abstention doctrine is an independently sufficient basis for dismissal. So happy to answer any questions about the motion to dismiss.
I think you've answered that. I've got 4 pages of questions, and they've been one by one chipped off the list here. So,
all right. Thank you, Your Honor.
Thank you. All right. We have time for one more round from all 3 attorneys. Okay, Mr. McClellan. We only have, it's only 4:08, and the bell will ring at 5, I hope.
Okay. Thank you, Your Honor. And again, if you have any questions, I'm happy to address them. The argument that I heard that we haven't met our burden to show irreparable injury because we haven't proposed some specific plan of action, I don't understand that. Nothing in the case law requires that. What we are arguing is that under the bylaws, we have governance rights as the 2 remaining members of the conference. We are entitled to govern. They are trying to deprive us of our governance rights in violation of the bylaws. The cases all say that that alone is irreparable injury. You don't need to then say, well, I would have gone out and done this or done that, because the reality is if they're depriving us of our right to govern, we can't go do those things. We can't go negotiate with anyone or talk to anybody or make plans because there is right now a complete lack of clarity about who the board of the Pac-12 is. So to say that we haven't met our burden because we haven't come in and said, here's our turnkey plan, when we can't even get to a turnkey plan because they're denying us of our rights to be the board, it just seems to put the cart directly before the horse. So the fact that they're taking away our governance rights unfairly, unjustly, and in violation of the bylaws, there's no question that that constitutes irreparable harm, both as a matter of law and as a matter of fact. Because again, you have to consider what they think the right result here is. They think the right result is that they should be entitled to make decisions on behalf of the Pac-12 over the next 9 months. And I found 2 particular exchanges during the last round to be very, very interesting. You asked Mr. Lambert, who doesn't the Pac-12 want to have a future and who should decide that? And he said Oregon State and Washington State should decide the Pac-12's future. That's what I heard him say. But we can't, because they refuse to accept the consequences of their decisions, and they are refusing to let us act as the board as is required under the bylaws. You then asked Mr. Levin, well, wait, doesn't the Pac-12 have an interest in having a future? This is when he said we don't want them spending $1 going out and trying to find new schools or regrowing this conference. And you asked him, well, wait, isn't the point of the Pac-12 to exist in the future, and isn't the point of the Pac-12 to go on and survive? And he kind of ducked the question, and he said, well, we're fine with Oregon State and Washington State having a future. But he didn't ask the question, he didn't answer the question of, do they care at all about the Pac-12 having a future? Because the reality is they don't. And this is, you can see this so clearly through their position that all of the net revenue should be distributed out and just flushed out through the waterfall, immediately. Again, that issue is not before the court today, but the reason, if that were to happen, Your Honor, and I think it's very telling that they keep saying, give us all the revenue, give us all the revenue. They don't want to make a single provision for any of the significant liabilities that were incurred while they were in the conference, but are not going to come due until after they're gone. So what organization in the world would send out all of the revenue and make no provision for the liabilities? That doesn't make any sense to me at all as far as sound management. But of course, it doesn't matter to them because they won't be here when the liabilities hit, and that will destroy the conference right then. They also make no provision at all for how any of that money should be used for the Pac-12's future, because of course they're not going to be a part of that future. So this idea that we have to come in and say, here's all of our actions 1 through 100 that we're going to take before the board is just not the standard. And I think it's self-evident that we will suffer irreparable harm unless we're entitled to act, and to act now as the board of the conference. I heard about the harm to student athletes. Again, I think that's a red herring, Your Honor. No harm has befallen any student athletes for USC and UCLA or Colorado since they've been removed from the board. There are councils that are set up within the Pac-12 to deal with on-field activities, to deal with student athletes. All of those have proceeded apace throughout the last 13, 14 months as those schools were removed. So everybody is operating on the same playing field, no pun intended, with respect to student athletes and with respect to keeping all of this going over the next year, which will happen regardless of who the board is. The question, again, boils down to who's more likely to be correct under the bylaws, us or them? And if we're right that our interpretation is correct, should we be empowered to act now, or do we have to wait for 6, 8, 9, 10, 11 months when it's going to be too late? Because decisions, if the Pac-12 is going to have a future, it's got to start acting now and making decisions in preparation for that. And we can't do that if we're handcuffed to 10 members who only care about one thing and one thing only, and that's draining all the money out of the conference and leaving all of their liabilities in the conference on their way out the door. There will be no future if they have a say in it. And Mr. Levin also said, and I think I got the quote down exactly, he said, we're not out to end the conference. And I think that's interesting because they spend 2.5 or 3 pages of their brief coming up with this very novel and creative argument that they can dissolve the conference even if they're not the board. They're wrong about that. That's another red herring that we've listed. But think about that for a second, Your Honor. The fact that they're spending that much time and energy and money to develop these novel legal arguments that they can dissolve this conference even if they lose this motion and even if they're not the board, just imagine what they're going to do if they are the board, and just imagine what they're going to do if they have some sort of veto right or unanimity right that we put in place for a temporary period to get from the TRO to where we are today. And I don't want to take the bait, but the suggestion that this USC and UCLA issue was that there was a pin was put in that, or that this wasn't decided. If I can just spend 2 or 3 minutes showing Your Honor how that all unfolded, because the facts are just directly the opposite. So if you look at slide 19, Your Honor. So we all know June 30th, 2022. And again, this goes directly to who is more likely to prevail on their interpretation of the bylaws. That was the day that USC and UCLA announced publicly that they were going to join the Big Ten, but they weren't going to join for another 2 years until August of 2024. That same day, the commissioner said, get me the other 10 presidents and ADs or chancellors, get me the other 10 board members on the phone with the ADs. Obviously, the point of this was to talk about what are we going to do about USC and UCLA announcing they're going to leave, and what does this mean as far as their governance rights are concerned. 4 days later, the very next slide, the general counsel of the Pac-12 sends a letter to the general counsel of USC and UCLA and says, you have delivered notice of withdrawal when you told us on a Zoom call or a phone call that you plan to leave in 10 years. So again, in black and white, unmistakable terms, adopting our interpretation of the bylaws and rejecting their interpretation of the bylaws. And this was not a secret to the board, the 10 remaining schools, including the University of Washington, who's represented here today. The very next day, if you go to the next slide, Your Honor, on slide 21, the board met the very next day, the 10 remaining members, including the University of Washington, and this is the presentation that was made to those 10 board members, along with everybody else. And it says, under legal and governance action, there is a notice and preservation letter sent out. That is a direct reference to the July 4th letter that went out the day before telling USC and UCLA that they had provided notice of withdrawal. It then says, board review of discipline and financial penalties. And again, you could only talk about disciplining and imposing penalties on those two if they had breached the bylaws. Then it says board seat and votes. I'm going to take a wild guess and say that that was a reference to should USC and UCLA still be entitled to attend board meetings and vote. And we know what the outcome of that discussion was, because after this day, USC and UCLA never attended a single board meeting and never voted on a single issue, even those issues that directly affected them, affected their revenue distributions, affected any and all manner of things that pertain to their existence in this conference. They were barred. And then it goes on to say removal of USC and UCLA from all NC2A committees. They not only took them off the board, but they took them off every NC2A committee in which they were on that committee as a representative of the Pac-12. There are many committees made up of board members from the different conferences, and they said, you're off of those too. And it also wasn't a mystery, Your Honor, as to why they were being taken off of it. If you look at slide 22, this is now 9 days later. The conference wrote another letter to USC and UCLA and told them exactly why they were being taken off the board in all of these committees. It was because of their direct conflict of interest and the fact that their participation on the board or their participation on these NC2A committees would harm the Pac-12 because they were conflicted. And they go on to say that the wide array of potential conflicts is so entrenched and ever present that recusal is just not a workable alternative approach. The words of the Pac-12 9 days after they met with the board and walked them through this exact issue. So for them, and then if you go on, Your Honor, on the next slide, 23, this just goes on and on and on. On October 30th, the General Counsel writes to USC again and says, our position is that you provided notice of withdrawal and you're off the board. Again, adopting our interpretation and rejecting theirs. And the very next day on slide 24, the board met again as a 10-member board, knowing full well that USC and UCLA were gone. So for them to come in here and tell you that this USC-UCLA issue, it never really, was a thing, and no one ever really took a definitive position, and it was kind of an agree to disagree type of situation, is completely contradicted by all of the documents and the entire evidentiary record before you. The course of performance is legion, and it shows that our interpretation was the interpretation that they all took up until the minute that that interpretation no longer served them and in fact would not benefit them in any way. And at that point, they did a direct 180, they did a direct flip-flop on their interpretation, but you don't get to reverse your interpretation on a contractual provision just because it no longer suits you. What was good for the goose is good for the gander. And the fact that they eliminated USC and UCLA and Colorado from the board, continued to meet and take action, and then when 5 more left, and then you had 4 remaining members, and the commissioner said, we have a board of 4 now. So each time this happened, it was well understood what the outcome was. It was the people who were staying, they're on the board. People who are leaving, they're off the board. And the fact that it's now 10 against 2 should not change the result. It doesn't change what the words say. It doesn't change what's fair. It doesn't change what's right. It just now happens to be 10 against 2. But 10 wrong and 2 right doesn't mean that the 10 should prevail. And that's what we have here, is a real clear situation of 10 in the wrong, 2 in the right, and the fact that they're 10 just frankly shouldn't matter. So again, happy to answer any questions that the court has, but the preliminary injunction that we've asked for is asking for nothing more than what the relief that they granted themselves when people did what they are now doing. What we want is a declaration that, or a preliminary injunction saying that we are likely to prevail and we should act as the board. That is the relief they granted to themselves when USC and UCLA said they were leaving and when Colorado said it was leaving. What they did was they said, you're off the board, we're the board, and we're going to decide. We're asking for the exact same thing. It's no different.
Okay.
Thank you, Your Honor.
Got it. Thank you, Counsel. All right, Mr. We're going to have one more round. If Mr. Lambert wants to add anything to that. Or subtract anything.
Your Honor, the conference and the commissioner have nothing to add, and we submit on the papers and what we've had to say today, unless Your Honor has questions for us.
I don't think you have. You've answered the question. Thank you, Counsel. All right, and Mr. Lambert.
Thank you, Your Honor. I'm going to work backwards and start with the equities and then talk about the bylaw itself. Your Honor, let me go back to this question of what is the purpose of the conference, and is the purpose of the conference just to exist in perpetuity and all money should be spent in service of that? Because that's not what I think I'm hearing, that all the money should first go to service of including paying other schools to join the conference this year. And the fact is, there is a statement of purpose in the bylaws. And the statement of purpose, which I read earlier, talks about supporting the member institutions in their athletes. And the way to do that is to make sure that members have a say in the governance of the conference. That does not mean that Oregon State and Washington State are going to be precluded from ensuring a future for themselves and for the conference. And that's true for two reasons. One, as I said at the outset, the University of Washington has said all along that it has no interest in participating in decisions about adding new members or new media rights agreements. And two, there is, in the declaration from President Kelsey from the University of Washington, there is evidence, it's unrefuted, that the conference has revenue streams coming into it next year and the year after. And frankly, if Oregon State and Washington State want to commit those revenue streams to paying new members, that's their prerogative to do that.
The President's declaration stated that she didn't have any knowledge of any of this action going on, and she was on the board chairman.
Yeah, no, I don't think she meant to say she of course knew that UCLA and USC were not in the board meetings. I think she says that. Of course she knew that. She was there. And what she says is there was no board vote to make a formal determination that they shouldn't be there. Simply the conference said they weren't going to be there, and it's true that others came to the meetings and went along with that in the sense that they didn't stand up and insist that UCLA and USC be brought in. And I believe the record reflects in President Kelsey's declaration that they were largely speaking about a new media rights deal, which USC and UCLA themselves had said they understood they weren't going to participate in those discussions. Now, the idea, though, that because the conference kicked UCLA and USC to the curb on July 4th after they announced, does not mean that that is the correct interpretation of the bylaws. And I heard a lot of rhetoric about good for the goose, good for the gander, and all these things, but 2 points, Your Honor. One, they are not making, and I have not heard them make, an estoppel argument. Different legal argument. That's an argument that says, you said it before, you said it to the court, right, you're stuck with it. You can't come into the court and say X and then come back a week later and say Y because it suits you. But there's a requirement for estoppel, which is that you have to have relied on it to your detriment. So we address this in a footnote in our brief, footnote 8. They don't address it, but there is no plausible way that Oregon State and Washington State could stand up and say the reason we've decided not to leave a new join a new conference, the reason we've decided to stay in the Pac-12 is because we understood that we would be the sole board members. They haven't said that. There's no evidence of that, and I submit that that's simply inconsistent with a record that is before the court, which shows that they did explore an attempt to join other conferences, but so far have been unsuccessful. So I don't think they have an argument to say, you're stuck with it because you said it before. So then you're left with, when is evidence of past conduct relevant? And there's been a lot of talk today, but they haven't mentioned a single case that says they get the benefit of course of performance evidence in this circumstance where it is indisputable that USC and UCLA, parties to the contract, parties to the bylaws, absolutely disagreed from day one with the conference's position. And what the California Supreme Court said in Warner, and this is a California organization, what the Supreme Court said is that is not relevant to the meaning of a contract. What's relevant is when all of the parties to a contract act one way in the absence of a dispute, and all of a sudden a dispute arises, and then they say, no, the contract means something else. All of this evidence is in the context of a dispute. And I would submit that it's largely driven by the conference's position initially to take a very hard line with USC and UCLA, and then to take a hard line with Colorado, and then to change its position also as a result of this all being disputed. That is not evidence that should overcome what the bylaws actually say. And what they actually say is you cannot leave during this prohibited period up into August 1, 2024. But you can leave after that. Everyone agrees. And you can tell people about your intentions. Nothing in the bylaws prohibits that. It's good to tell people about your intentions, and they do not mean that by doing that you have violated the bylaws. Think about that. The provision is you are in breach of the bylaws if you, in good faith, tell the members that you are doing something that is absolutely permissible. That is, you tell people, you tell the schools that you've worked with, that you have relationships with, that you are planning to leave the conference after August 1, 2024, and they say now you are in breach. I heard him say you are potentially subject to penalties. You can be punished for this. But that makes no sense. The only way then you can actually leave, which you have the right and the permission to do, is to stay utterly silent until August 2nd, 2024, and then announce we're going somewhere else. That's not practical, and it's not reasonable.
Why wouldn't that be practical?
Well, it's not practical because now it puts everyone in a really difficult position, right? Because the conference is at that point trying to negotiate a new media rights deal, right? This is all tied to a media rights deal. They're trying to negotiate a new media rights deal leading up to 2024. You have to set schedules for the future. You can't set schedules at the last minute. So lots of things are going on about the future. And if you say one word, you're in breach. But if you sit there silently and sort of pretend to go along, you're not in breach. I mean, that is illogical because now you have things that are being put in place that don't apply to you. You're being put on some schedule. It's not part of you. But yet, if you say, by the way, we're not going to be here starting in 2025 or 2024, 25, then you're somehow in breach of the bylaws. This is not a provision that says, like the old provision, which said, you must tell us. The old provision said, you must tell us. You must tell us in advance. And effective when you tell us, you're off the board. But the new provision just doesn't say that. It's not the words on the page anymore. Your Honor, I submit there is no evidence in the record about the why, about why that happened. Maybe that could be explored at a further hearing on this, but there is no evidence in the record about why the change was made in 2011 from the old version to the new version. But what we have are the words on the page, which are quite different and which are focused on keeping members in the conference during the term of the media rights agreement. And that's what the bylaw provision is talking about. It's not saying when you tell people about your future permissible plans, you are kicked off the board and can then be subject to essentially any action that the remaining board members want, including withholding of revenue that you have contributed to earning as part of the conference. Let me say one more word because a couple times this issue of the conference's liabilities have come up. And the conference is a defendant in certain lawsuits, but again, I would submit, Your Honor, there's no evidence in the record about any of this. They put in declarations about lots of things, but they don't put in any evidence about the liabilities. There's simply no evidence before the court about anyone's intention with respect to the liabilities. The only thing I will say on that, Your Honor, is in the past, when liabilities have arisen, the conference has paid them. And frankly, there's no reason to think that won't happen in the future, but this is just not something that's before the court at this time. And the last thing I'd say, Your Honor, is on this question of dissolution. Because Mr. McMichael called it a novel argument that the members could dissolve the conference if they wanted to. Your Honor, with respect, it's not novel. It's what the California statute says in black and white. If the bylaws don't provide a mechanism for dissolution, then it is up to the voting power of the association to decide whether to dissolve. And the California statute goes on to say the voting power of the association resides in the members. The cases are absolutely clear on this. It's simply the fact that the members could decide to dissolve if they wanted. Of course, in all this time, during these proceedings and before, no member has called for such a vote. No member has tried to dissolve. But this injunction that they're asking for, and the reason we put this in our papers, is because this injunction is not going to address that issue. That issue is simply a separate issue about should the members choose, a majority of the members choose to dissolve the conference, which I will say no one has attempted to do it as I stand here today, but it is simply not something that they need board control to prevent or to make happen. It's just not a decision that's committed to the board. It's a totally separate decision. They talk about in their papers, but they have no contrary law, and they have no other reading of the statute. So let me close, Your Honor, by saying the departing members continue to have an interest in the conference. They continue to play on the field. They continue to play on the courts. Their student athletes are participating in competitions, will continue to participate in competitions, and they continue to have a say or to want and need a say in conference governance. The bylaws do not kick them off the board automatically for telling the conference about their future plans, and this court should deny the preliminary injunction or at a minimum grant one of the alternative remedies that we suggested.
Thank you, counsel. All right, well, we've come into the decision time. Thank you all, counsel, for your very passionate and well-organized thorough presentations of your respective cases. I've read and reread, and like I say, I think I've read 3 times all the papers that have been submitted, except I did not read every page of the bylaws, I'll tell you that much. It just seems, I grew up where conduct spoke louder than words. I mean, that's how my parents treated me, and that's how I treated my children when they were growing up, is that conduct is what counts, and words don't so much. What you do is what you do and how you do it is what counts in life, not what you say you're going to do, not what you say you're not going to do. So with that in mind, this court finds in favor that the plaintiffs are likely to prevail on their interpretation of the bylaws. The party's prior course of conduct uniformly supports the plaintiffs, and the plaintiffs will suffer irreparable harm without the preliminary injunction. Now, with the preliminary injunction in effect, that will be in effect, I'm going to order that the WSU and Oregon State will be the only 2 governing members of the board, but if they hold for any future meetings or conferences between OSU and WSU, they will notify the other 10 schools. They will put forth an agenda. The other 10 schools may participate in the sense of making comments, suggestions, or objections. The ultimate voting will be by the remaining 2 board members. But this is not a shutout in the sense of the preliminary injunction will be modified, or whatever you want to call it, to make sure that the other 10 schools are still treated in a fair, open manner. Nobody's going to take advantage of somebody else. And if that starts to happen, I'll either hear about it here or somebody else will hear about it down the street up the highway. But I just do not believe that the 2 plaintiffs left here, the 2 members of the board that are left, will do anything directly to harm the other 10 members. I've read too much here. I've read all of what you've got to say, and with that, that's how I see it. And that's how I guess that's where you came to find out how the court would rule, and so that's what we're ruling.
Your Honor, if I may, and I appreciate the court's ruling, we do intend to seek review of the Court of Appeal, and we'd ask if you would stay your order until the end of the week so we may seek a stay from the appellate court, if they decide to impose a stay.
But leave in the TRO.
You leave the TRO, yes. Leave the TRO, but stay in position of the PI until the end of the week so that we can seek appellate relief.
Okay. All right. Any objection to that?
No, Your Honor, if it's just until the end of the week, we don't object to that.
Okay, fair enough. All right, let's put together that preliminary. I was looking for it up here on my notebooks. And so you've got a proposed preliminary injunction that I had. Can't find it.
I'm happy to hand my copy up, Your Honor.
Yeah. Yes, sir.
One request, I think it's implicit, but we'd like it explicit. One carryover into the new order from the TRO, which is a clear demarcation that the conference can continue to conduct its business in the normal course. In other words, the kind of business that it conducts without normally seeking consent or at the direction of the board.
Sure, I don't think that's an issue, but glad you have that in there, Mr. Michael. Any problem with that?
Not in theory, Your Honor, just as long as we're all clear that that does not include decisions about distributing revenue or where, how the revenue should be spent. I assume he just means normal course, general day-to-day activities, but not the decisions that the board would normally be involved in.
Is that what you mean, Mr. Lambert?
Your Honor, another thing that seems unsaid but clear, I think everybody needs a ruling on the motion to dismiss.
I'm sorry, can you use the mic, please?
Yes.
The
You're on.
court denies the motion to dismiss. Thank you for bringing that up. Because the court finds that the 9 departing schools are adequately represented here in today by the University of Washington, who has thoroughly represented their interests. So let's just take a look going through the wording here of the preliminary injunction. Order granting principle. So let's go to the meat of this order. All right. Okay, so we would add, we're going to add, I probably need to have it, maybe to just add on the back, I don't know. It's, we'll say number 4. All right, so number 4. The conference shall be able to operate in its normal course of business. Number 5. Any future meetings of the board shall be noticed, I guess you call it that, for 3 days to all other 10 departing members. The new board shall invite all departed or departing, because departed universities Participate. Okay, so here's what I've done on I've added paragraphs 4, 5, and 6. I have one this order is stayed until, this is making the next Monday, it's Friday.
Monday would be the 20th.
Right. Okay. Monday at noon, November 23, during which time the PRO 9/11 will remain in effect. Appeal this order. Okay, here's what I've added. All right, the conference, number 4, the conference shall be able to operate in its normal course of business. Number 5, any future meetings of the board shall be noticed 3 days to all other 10 D-party members. The new board shall invite all departed universities to participate, communicate, and submit their suggestions to the board. This order is stayed until Monday at noon, November 20th, 2023. November 20th, 2023, during which time the TRO of 9/11/23 will remain in effect pending appeal of this order. I think I got it in that one down there. So be it.
Thank you, Your Honor. Thank you.
14th November 2023. And does anybody have a motion denying or only denying the motion to dismiss? If not, I can add it to the back of this.
Yeah, we don't have one prepared on that, Your Honor, but we're happy to do it, or we can just say the motions to dismiss or deny. That might be easier.
Just add that.
Okay, thank you.
Nothing's going to change in fact. Well, athletes will still be competing, schools will be still doing business, Pac-12 will still be doing business, but it'll be governed by the 2 universities that have not submitted their notice of intent to withdraw.
And Your Honor, may I just seek one clarification? I think we're all on the same page, but I think it's better to ask than guess. When you say normal course of business, I think we're all assuming that does not mean that the conference can decide whether or not to distribute out all the money.
That's the board decision.
Correct. Yeah, I mean that's our position, is that the board would obviously need to be involved in that. And I don't think Mr. Lambert was intending to suggest that would include it, but just don't want there to be any ambiguity about what our view is of that.
Okay. Yeah, but the decision to make distributions shall be that of the board. We'll need to read it right.
Your Honor,
Yes, sir.
could I just ask for one clarification of that? We're fine saying that the decision to actually effectuate a distribution can't be made by the conference unilaterally, but distributions and what is distributed to whom is covered by the bylaws, and I just want to make sure that the order isn't affecting a change in the bylaw, executive regulation section 1. About if the point is just the timing and when money is paid out and so forth can't be unilaterally taken by the conference, that we understand that. We understand that the board could decide the time cadence and so forth, but I just want to make sure we're not actually changing what the bylaw says, because that wasn't in the motion, that wasn't part of the request for relief.
That's my understanding, counsel, that there's no change in the bylaws, that the remaining bylaws
Or what they are.
yeah, will be adhered to by the new board members.
Thank you, Your Honor.
Or by, I should say, the remaining board members, not new. Well, thank you everybody for your hard work in this case. It's not your work. Court will be in recess, and thank you everybody for your participation and doing what you want.